23, WPC 2746 of 2016.
Milords, I am appearing for Watco Milords. In item 23.
You have to use the mic, sir. Whatever you're talking, speak loudly into the mic, sir. If you do not mind.
Yes, Milords, I am appearing for Watco Milords.
Yes.
I have been
What are the test results, sir?
Yes, I have given the.
No, is it good quality water, bad quality water?
Bad quality polluted water.
Sir, let them answer, sir. You are for the petitioner, no?
No, I am for the pollution control board.
You are for good.
I have given the test results.
I am for the petition.
It's polluted.
What are you doing, sir?
Milords,
You have the test result now.
yes, Milords, Watco is not concerned with this, Milords. This is only JICA is constructing, and there is a drain.
Sir, untreated effluent is coming to the river. Watco is not concerned.
No, Milords, this is because of it is only this JICA is taking this construction work OASIP.
So construction work is something. Untreated effluent coming to the river is another thing.
Yes,
if you are seriously making the statement, I'm going to record it in the order and ask the managing director to remain present.
Milords, they have not yet received the notice, Milords.
You will receive notice right now. In fact, the last notice said you have to deliver it to the managing director.
Yes, Milord, that has not been. I have.
Sir, let me make it very clear. If your managing director wants all this red carpet welcome, you can do it.
Milords,
He wants red carpet welcome.
Milords, next week they may appear, Milords.
What is next week? May appear and all.
No, because of that.
Sir, matter is serious.
Yes,
The matter is serious.
I obey.
Your managing director wants a proper red carpet welcome.
I have obeyed, Milords.
What is obeyed?
Go down, Milords. Because of next week he may appear, Milords. Because
No. Are you going to have this attitude? I have nothing to do with it.
No, Milords. Because of them not.
No. We will record the statement that managing director of Water Corporation Orissa says I am not concerned with pollution of Kajjodi River.
No, Milords.
I will record that statement.
No, Milords. I am not telling that aspect, Milords. I have only got to appear in this case only because of.
No instruction, nothing. Because they've asked you to appear, you simply appear.
Yes, I have.
How are you assisting the court?
Milords, they have not received in the next date. We will file our.
Sir, you have this test report. Where is this? No. You given only one copy.
No.
Give it to him, sir. Somebody has to do something about it. Sir, are you aware of reading test results or even that no instructions? Appearing for a Water Corporation Orissa, do you know how to read the pollution control reports?
We have got it. And I
Does your managing director know how to read, or even he will come and say the same thing?
Yes, sir. Next date we will.
Sir, no next week and all, sir. Pollution doesn't stop for any week. Even as you are speaking now, some untreated effluent is being discharged.
Milords,
You know why we kept it today? We thought by now you will be so shocked with this report, you will do something about it.
Milords, let it be day after tomorrow.
Sir, ask at 2 o'clock. I'm going to call this. I want the managing director to appear in virtual mode. I think you don't understand the real seriousness of it. Your managing director also doesn't understand the seriousness. We're sorry to say this.
Milords, by tomorrow.
We are sorry to say this. 2 o'clock today, I want the managing director to appear in virtual mode. Tell the managing director. I don't think you realize the seriousness of these matters.
I pray, Milords, by tomorrow, Milords.
Sir, I pray to you that the managing director will appear at 2 o'clock. You say the managing director of Watco will appear in virtual mode at 2 o'clock today in this court. This order be communicated telephonically immediately. What is the mobile number of your managing director? Give us the managing director's mobile number, sir. Watco has the managing director, no?
Yes, Milords.
Give us the mobile number of that managing director.
No, it is still pollution control.
I think only judges are worried about all this. Nobody seems to be worried.
I am giving with a sleep, Milords.
Please ask him to remain virtually present. Sir, have you understood what I'm trying to tell you? Have you understood what order we have passed? Have you understood it?
Yes, Milords.
Will you communicate it?
No, because of on the list, because of Watco was not a party, Milords, and this notice was.
Sir, notice has gone to Watco. This is a public interest litigation. Yes. You want some order 1 rule 10 CPC to be applied here?
No, Milords.
In our order, have you said Watco should be informed or not?
I obeyed, Milords. I bow down, Milords.
You keep bowing down, but nothing is happening, sir.
Milords.
Bowing down doesn't stop pollution.
Let me by tomorrow, Milords.
Sir, I am very clear. That's why I'm repeatedly asking you, have you understood what order we have passed now? Have you understood the order we have passed?
Yes, my lord.
Don't keep saying tomorrow, tomorrow. Have you understood the order or not?
My lord, I will try to communicate the MD.
This man is not serious at all, sir.
I will try
I'm so
to
sorry to
communicate.
say
He
this.
will remain present. I am getting his number and I will try to.
Please, you have a WhatsApp or you have some to send this to your managing director immediately?
Yes, my lords, by 2 o'clock, he will be present.
Okay.
This report, will you send it to him or not?
Yes, we have already the order of this.
No, report the WhatsApp
Yes,
report.
now a disciplinary report now.
The test
Yes, I
report
will
which has
send
been
it now.
shared to you,
I will
kindly
send
send
it
it
now.
to managing director
Yes.
so that he could apprise.
Sir,
the
kindly
court.
tell him over the phone not to come to the court and say, I have nothing to do with this pollution of a Katjodi river.
Yes, my lord.
Sir, does he have anything to do with this or not, your pollution control board?
Then your lordship asked the member secretary to appear in virtual mode.
We have already said that, I think.
Yes.
Member Secretary Pollution Control Board will also appear. Which is the other authority responsible for all this?
CMC is the main authority. They are not doing anything.
Sir, this passing the buck will not do.
No,
You
I am
tell
not
us
passing
which
the buck.
authority will do what? How will we reduce this pollution? Tell us that.
They have to set up the
Who's they?
government and municipal corporation to set up.
Watco has anything to do or nothing to do with this?
Yes, river pollution they have to. But
Are you
sewage
aware,
treatment
not
plant-
aware, nothing?
sewage
Nobody's
treat-
aware.
Sewage treatment plant has not been set up and not functioning. Only one.
Where is
plant
Mr.
functioning.
Devashish Naik?
That is the problem.
He is not here.
Beg apologies, member secretary is present. Beg apology, due apologies.
Yes, sir. Tell us.
No, Namaskar, sir. I am Murugesan, sir, Member Secretary, State Pollution Control Board. Sir, as per your Honorable Court, sir, we have already did the sample test and we have submitted to the Honorable Court.
Is it alarming or not alarming?
Sir, the mainly, sir, that fecal coliform, that is because of the release of untreated sewerage water,
Sir,
mainly
give
the.
us a simple answer, sir. Is this alarming, not alarming?
Very much alarming, sir, and we
okay.
have. Sir,
If it is alarming, what should happen?
Sir, actually, sir, they are having the STP under 102 construction at on the Kannahar. So if it is completed, sir, and provided if all the drainage points are collected to the STP, the fecal coliform, that's mainly the alarming contribution that will come down, sir.
No. From which source is this coming? This is coming from the city sewage or where is it coming from?
Sir, it's coming from the city sewage only, sir.
So the city sewage is under the control of Watco or not?
Sir, city sewage is under the control of the CMC, sir. So CMC is constructing the STPs and the STPs, sir, the CMC executive engineer is also online, sir. He will be able to tell whether it has been.
What is the
constructed
role of
or what.
Watco? Does Watco have a role or not? Last hearing we were told Watco has a role. Are they concerned about clean water resources in Orissa or they are not concerned?
Sir, they are concerned, sir. They are because they are in the process of constructing the water pipeline and water lines and sewerage lines. So they should be
Let's
concerned,
talk to
sir.
Mr. Tripathi, Mr. D.R. Tripathi. You have to unmute Mr. Tripathi.
Sir,
You are in your office now.
sir, in my residence, sir.
Why? It's 10:40. How come you are in your residence?
No, sir, I am only open the but net problem is at our CMC Vikas Bhavans. Now, sir, due to which I have.
So what is your responsibility as CMC, sir? Untreated effluent is coming into Katjodi River.
Sir, now, sir, sewage treatment plant work is going on by JICA at Matgaspur, and sewage system is going on. So
No. How will you stop this effluent from getting discharged?
Sir, now we will close the gates. Then we will pump out the water to the Matgaspur. Through pumping on now temporary pumping systems. Okay. We'll trying to pumping the water to the main drains. Then JICA is constructing both drains and sewage system in Cuttack. Both the work is going on. they have make a coffer dam at Gosala, due to which sewage water and storm water can't pass to the Matgazpur. His work is going on now. At
So
Gosala
going on means what? Work is 20% complete, 10% complete, 5% complete, 40% complete.
Here, from their reports, they have already completed 70% sewage systems, and drainage system is less than 50%.
So then what will happen this monsoon, sir?
Monsoon will open the gates, but non-monsoon periods only we close the gate and pump out the water to the.
No. So monsoon period, sewage will flow freely.
Sir, due to in monsoon periods there is when pollution is very less due to mixed storm waters. Pollution is very less.
This is all your own theory, sir. The person who suffer is the persons who are drinking that water.
Sir.
There's no planning, sir. There's a whole problem. You know, monsoon is coming. Waterborne diseases go up in any city.
Sir.
Waterborne diseases because water is polluted.
Sir.
Is there any role for Watco or there's no role for Watco?
Sir, it is now JICA's main role is for JICA, sir. OSCP, Orissa Water Supply and Storage Board. OWSSB is the main roles. He is constructing the sewage work and drainage work.
Why did you say Watco? Last time you were the one who said Watco.
No, sir. Watco is only for supply of drinking waters. Now he is maintaining the sewage system of CDA now. After completion of JICA work, JICA will hand over the.
We were told there is a grand plan to get drinking quality water in taps in Cuttack. Will that happen?
Sir, already they are taking the raw water from the river Mahanadi, not Kathojodi. They are drawing water from river Mahanadi only.
What is Mahanadi's pollution level? There is no pollution there. No. All your sewage is going into Kathojodi and not Mahanadi.
No sewage to pass through the Mahanadi. Only at Khannagar there is a direct storm water. They have blocked the main drains due to which storm water and sewage water pass to the Kathojodi river Kathojodi. Sir.
So who's JICA is a separate agency?
Sir, JICA is under the control of
CMC is only the contract is between CMC and JICA, no?
Only, sir. Through CMC only, just monitoring the system. So JICA is directly to the execute.
No, JICA is simply executing the project, sir.
Sir.
Till the project is complete, how will you control the pollution? That is the question.
Sir, after completion, his operation.
Okay, who is setting up the sewage treatment plant? You are setting it up, correct?
No, sir, JICA. OSFP, JICA is constructing STP.
So what will you do? Till then, what are you planning to do? How are you planning to control?
Sir, now we will stop the gate and pump out the drain to main drains. Then it will pass to the 33 MLD existing STP is running at Matgazpur. There, the treated water will pass to the river Kathojodi. 33 MLD STP, old STP is in running conditions.
So we will call it on Friday, this Friday. You better put all your steps that you have taken on affidavit.
Sir.
Sir. Say all right. You meanwhile ask Watco to be present. All right.
Yes,
time. You see the superintending engineer of Cuttack Municipal Corporation appeared in virtual mode. Mr. Nayak, you're there.
My lord.
So this is basically CMC's the main agency here.
My lord.
See, we have got the Central Pollution Control Board report.
My lord.
There is fecal matter. It's very high pollution. The Secretary Pollution Control Board has told us it's alarming.
My lord.
So now the superintendent engineer says he will stop discharge of effluents. He'll close the gate.
My lord.
And divert it to the existing sewage treatment plant.
Sir.
But actually we are worried about what will happen in monsoon, sir.
It will be a bigger problem.
Sir, and he seems to think because the flow is there, somehow pollution will come down. It won't come down.
That cannot. Unless the effluents are not taken out from the water, treated, that's not going to go away.
And I would ask the State Pollution Control Board, Mr.
Murugesan, sir.
Mr. Murugesan.
Sir.
Do you regularly test the river water quality?
Sir, we test the water quality every month, sir, at 3 points in
What's the position in Mahanadi?
Sir, Mahanadi, sir, it has water quality is good, sir. We have got the category of 5 categories, and the Mahanadi is number 1, sir. So quality-wise, it is in good condition, sir.
But where do you send your reports to whom? You send it to all the municipal corporations?
Sir, we send it to all the municipal corporation, and we are at the state level also, sir, we have got the River Rejuvenation Committee. And the state pollution controls, when it is being headed by Secretary Forest, it is being reviewed also, sir. We also send our report to CPCB also. It is being reviewed by the government level, sir.
What happens in a city like Bhubaneswar? Where does the sewage go and where does it get discharged?
Sir, Bhubaneswar also, sir, we are having the one Nala which is passing through the city. So now they have constructed the STP, sir. So after that, the pollution level has come down, especially after the treatment. The main problem is the connectivity. Even the whatever the capacity created, it's not being fully utilized. That needs a lot of drainage.
This is an opportunity for you.
Sir.
You file an affidavit before us.
Sir.
Wherever you want the court order, which can expedite processes, which can control pollution, please tell us what you need. All right. Take this as an opportunity.
Sure, sir.
Point out everywhere in Orissa, wherever there are no STPs, we don't want rivers of Orissa to become drainage.
Sir.
Sure, sir. Because summer months, the water inflow is less. This is a real danger of only sewage flowing then.
Sir.
So you please file that affidavit. Can you do it by Friday?
Sure, sir. 100%. I'll definitely.
It's like alarm bells, right? Red, orange, green, that kind of a thing. Wherever there is critical danger, immediately action has to be taken.
Definitely, sir. Definitely.
Sir. You say you start like this. You say the Central Laboratory of the State Pollution Control Board, Orissa, has placed a test report of samples taken of the water quality of the water flowing through the Katjodi River. Dr. Murugesan, the Secretary, State Pollution Control Board, was present in virtual mode. He states that the total coliform and fecal coliform in Katjodi is far above the permissible limit. And according to him, to use his word, the situation is single quotes alarming, unquote, paragraph. The superintending engineer of the Cuttack Municipal Corporation, (CMC), is present in virtual mode along with Mr. Devashish Naik, counsel for CMC. After being informed of the test report, the SC CMC states that the sluice gate through which the untreated effluent is being discharged into the Katjodi River will be closed immediately and the water diverted through the existing water treatment, sewage treatment plant to ensure that untreated effluents are not discharged into the Katjodi River. Full stop. It still does not fully meet the requirement, particularly considering that the monsoon season is imminent. Full stop. He informs the court that what's the full expansion of JICA? Japan International Cooperative Agency, (JICA), is presently undertaking the work of construction of the drainage system, drainage canals, and what are the two things, sir?
Sewage system.
And sewerage system.
Sewage system and drainage system.
Sewerage system as well as the drainage system, which is around 70% and 50% complete respectively. Sewerage system is 70% and drainage is 50%.
Sir, about 50%, sir.
All right, around 50% respectively. It appears that these systems may not be ready by the time the monsoon arrives in Orissa this year. To stop, some corrective action will have to be taken, anticipating the monsoons. Full stop. A direction is issued to the superintending engineer, executive engineer, CMC.
Sir.
Executive engineer, CMC. To personally file an affidavit by Friday, listing out the steps that he proposes to take to ensure non-discharge of untreated effluent into the Katjodi River. Paragraph, the managing director, Watco, will also remain present in virtual mode on the next date to explain what steps are being taken to ensure availability of clean drinking water in Cuttack and what is the action plan in that regard. An affidavit should be filed by the managing director, Watco, in this regard by the next date. Then third paragraph, Dr. Murugeshan, member secretary, State Pollution Control Board, states that he too will file an affidavit explaining what kind of interventions are necessary by other municipal corporations in Orissa to reduce the discharge of untreated effluents into the various rivers, nalas, streams in Orissa. Full stop. This will help the court focus on situations which need immediate attention at the hands of the local bodies. List on Friday.
Let it be on Monday. Friday is a holiday.
So we'll have it on Monday, sir. Monday next. 4th April.
Monday, it will be like today, my lord, first item.
Four at 10:30 on Monday.
Okay.
All right, sir. Please communicate all of this. Us getting upset is only to communicate the urgency. All right.
Yes. Special weekly list, old matter, item number 1.
May I please, your lordship. Lordship, there is a delay of 376 days.
We go out on that ground itself. There is no convincing explanation given for the inordinate delay of 376 days in filing this revision petition. The court is not satisfied with the explanation given. Consequently, the delay is not condoned. MC 240 of 2013 is dismissed. Consequently, the STREV is dismissed.
Special weekly list, item number 2.
No instructions.
The counsel, the petitioner seeks leave to withdraw.
No instructions.
No instructions. All right. Disposed of.
My name may be recorded.
All right.
Special weekly list, item number 3.
May please, my lords. Lordships, I'm appearing on behalf of Mr. Sahu, my lords.
Yes.
The amount here involved is very meager amount, my lords.
All right. Since the amount involved is meager, the question of law is left open.
It is also covered, your lordship. It is covered by your lordship judgment.
All right.
That Goni bag, your lordship.
Should be taxed at 4% or 12%, my lords.
All right. In any way,
same contractee FCI is the same
stands
and
covered
supply
by the
is the
judgment
same.
of this court in Sri Durga Rice Mill versus State of Orissa, 2021 1 OLR 1042. Right.
Deeply obliged.
It's accordingly dismissed.
Special weekly list, item number 4.
Item number 4, no instructions, my lords.
No instructions. All right.
I pray my lords to pass a similar order for item number 11 also.
Item 11 also. All right. 11 also.
Much obliged.
Special weekly list, item number 5.
Your lordship, item number 5 is very paltry amount, your lordship.
Paltry amount, yeah. The amount being insignificant, the court is not persuaded to interfere. The question of law, however, is left open for decision some other case. The petition is dismissed.
Special weekly list, item number 6.
My lord, no instruction.
No instructions disposed of.
Special weekly list, item number 7.
7, your lordship. File is not there, but it is paltry amount.
Okay. The same paltry amount. So.
Special weekly list, item number 8.
8, your lordship, amount is 21,000.
But anyway, nobody is appearing.
Your lordship.
None appears dismissed or not.
Special weekly list item number 9.
9 is yours.
Your Lordship.
Paltry
20.
amount. All right. 10 also?
10,
Item
Your
10.
Lordship, 10, 10, I don't have file, Your Lordship.
All right.
so I
10,
can-
you say none of the council.
My lord, I appear for the opposite party.
All right. That he does not have the file. Dismissal non-prosecution. To be open to the state if the amount is substantial to revive the case. In case the files are able to
My
be
lord,
located.
the demand is 24,233.
Okay, you just say in any event the amount is paltry. The court leaves the question of law open for decision some other case.
10.
All right.
Special weekly list item number 12.
11?
No instruction. 11 is taken.
Ah,
No
yeah,
instruction.
yeah. 12, 12.
No instruction.
No instructions disposed of.
Special weekly list item number 13.
None appears. All these matters, dismissal non-prosecution.
I am for the state measures.
Interim order penny stands vacated.
Special weekly list item number 14.
None appears dismissal.
My lord,
Ah,
item number 14, my lord, they against the award of the labor code, my lord,
yes,
to writ application filed.
Yes.
I am the workman
okay.
and my senior is also on the management. I have filed the first case is my case, wherein, my lord, I have the labor code award is in my favor, but the compensation is granted 20%. I have for that reason I filed the writ application. Now kindly peruse page 20. The first case 19,329 of 2010. Page 20, the operating part of the award, I may permitted to place. That the admitted fact being that the management has not complied with the mandatory requirement of the provisions 25F of the Industrial Dispute Act, despite of the fact that the workmen had rendered continuous service under more than 240 days, the termination of the employment cannot be said to be either legal and justified, and the management directed to reinstate the workman in service forthwith and pay him lump sum amount of 20,000 towards back wages. That 20,000 back wages I pay before enhancement of that I came before lordship. My lord, kindly peruse the annexure 1.
No, have you got the demand draft? On 5th October, we passed that order.
My lord,
Yes, already.
similar case, my lord, has already disposed of in 3 cases, my lord, by the Honorable High Court as well.
My lord saying whether it should be money or not.
No, I have not. I have not no compensation amount.
No. 17B.
17B they have paid, my lord.
Ah.
17B they have paid.
What is the similar order?
My lord, kindly.
No. What was that similar order you were referring to?
Yes, ma'am. Tribunal order, page 29.
Similar order.
Not tribunal, sir. Similar order.
Yes.
Okay. What you are saying?
Right. What do you say, sir?
My lord, here the dispute is, my lord, the lower court has applied Supreme Court decision and stated that if the employment is on a scheme, temporary scheme, he cannot be reclaimed reinstatement. But said that the appointment, there is no evidence that appointment was a temporary scheme. My lord, kindly turn to para 8 of the writ petition of my friend, by my friend. Will not shoot documents. Page 5 of this writ petition.
18011.
No. 19329.
Page?
Page 5.
after closure of the scheme.
Yes.
Corporation consolidated with. Now she says, previous para, that the petitioner workman after receipt of the written statement submitted a rejoinder indicating clearly that petitioner had never engaged in time-bound scheme. The appointment of the petitioner clearly reveals that the engagement is totally as an employee of a corporation on consolidated basis. But he was directed to work in the time-bound scheme. He himself says, after the closure of the scheme, the petitioner was directed to
Where are you reading, sir?
service on the scheme.
Where
So
are
now
you
it is admitted by him.
So where are you reading?
I am reading page 5 of read filed by my friend. 19329.
Para number. Para number.
Para number 8. Para 8. Page 4.
After closure of the scheme, petitioner was directed to service
My
and
lord,
the
yes.
scheme has been seized.
Seized.
So
He-
directed to come back to his former post.
My lord,
He was directed to come back to the former post and he worked in that office.
now the question is, now it is our specific case with the tribunal that it is a time-bound scheme, so documents are filed.
No, but you are taking work from him, sir.
Yes, no doubt, but once a scheme is there.
No, how can
scheme
you
closes.
expect, you ask him to come back and work in the office, then why can't he not claim regularization?
My lord, the scheme is closed. Only this
You
government
should have
scheme.
not, you should not then taken him back. They should have asked him not to come back to work.
Yes, we have taken. We have said to go. My lord, see the next my read may be seen. My read petition. I will show 2 documents. My read petition, 11 read petition. My lord, kindly see. What is the terms of appointment?
Also, appointment annexure 1 only by see
I
annexure
wrote
1
one.
will reveal also.
Let me show to my honorable court.
Say you filed this writ petition only because he filed it.
No. We
You
have
filed it in 2011.
Yes.
Ah,
They
much
filed in 10.
later. Much later you filed
No,
it.
no. They filed in 10. I filed in 11.
That's what, one more year, sir.
Not 1 month, some few months.
No.
Madam, see. Well, kindly
What is the
see
date of the award? 1 minute. Award is dated 29 January 2010.
My lord,
When did you file this writ petition?
I have filed in July.
July 2011.
July 11.
1.5 years later.
Madam.
Ah.
Madam, see the letter of appointment. Madam, this is a legal point. What is the terms of appointment? Kindly see. Letter of appointment is.
Sir, all these letters say purely temporary, purely ad hoc, all that. It's a
The-
standard letter. Everywhere it's only
the-
purely temporary.
Madam, see page 13 for a moment. Page 13. I have executed all the schemes, government scheme, government asked you to open it. Then, madam, see,
Sir, if he has worked 240 days continuously with you, that's the main point.
The
right?
only mistake on my part, not to pay the return on compensation. The scheme is closed. Well, the
There's no
scheme is
mistake.
closed.
There's no mistake.
No,
You want his work, you're taking work from him.
no,
That's it.
that was way back in the 93 minute, he is out. Madam, see, madam, kindly see Annexure 3 for a moment.
All right.
For minors, kindly.
All right.
Annexure 3, page 13.
How old is your client, sir, now?
You must have reached the age of retirement. by now.
Acharya, how old is your client?
He is now 58 years old.
So nothing, sir. He'll only get some 2 years of work. Nothing.
Well, he has already received lakhs of rupees by 13.
Because of your
17.
attitude. If you don't file, then you don't have to pay him those lakhs.
For kind consideration, my lord, for a moment, my lord. I'll see the letter of appointment.
Yeah.
Letter of
See, the
appointment.
logic seems to be this. I will pay him lakhs of rupees, but I will not let him work.
That was a decision taken then.
What
I was
is-
also
what
young.
is the logic of that? I don't
My
know.
lord, I was not a senior advocate at the time. It was way back, my lord. So,
All these labor matters, management pays lakhs of rupees, but does not want to
well, there is
take
no
work.
work for that time because the scheme is closed. We don't have to work to engage them. That is the reason. Madam, see, one moment. Madam, this is the Ratnakar Vishwala, outsider, Borara. He appointed as a sales assistant on temporary basis to sell center in SRPP center as Shishwa, 450 rupees per month. That is on the scheme. Then,
No, madam.
I'm showing the document to my lord. But see, then annexure 11. Annexure 11, kindly see. Rather 10, my lord. In 10, government issues a letter, we are stopping the subsidies. No subsidy will be paid. 10. Then, annexure 11, we have said, Ratnakar of Barala, an outsider, now working as assistant at our Salipur RCMS depot on temporarily with the consulate pay of 650 per month, each retrenched his service with a veteran 3493 as the different schemes of the government of Orissa have been withdrawn. And I have no business. This is the condition. He says, admit this lower court relies upon that the Supreme Court decision, saying, well, let me see that portion of the order. Apply that the Supreme Court decision if it is a scheme, you cannot claim it. That is the law of the land Supreme Court. You engage on a temporary scheme.
When did the scheme come to an end?
Scheme completely 93 million.
No, which? No, scheme came to an end much earlier, sir. 91.
92.
No. Annexure 10, page 32 is what you referred to. That's 91.
91.
So till 2 more years, look at this. See, you do not terminate him immediately on the coming to an end of the scheme. You keep him for 2 more years after the scheme.
He has got business.
No, so this was nothing to do with the scheme coming to an end, sir.
Only to closing of the accounts. It is not necessary that I will continue forever.
No.
Because
Once you
engage in a scheme.
So it is not co-terminus in the scheme. That's the point. If it is co-terminus in the scheme, you'd have terminated him 91 itself.
Day, but on the closure of the shop, we have terminated him. And we have paid him so much of money. And one thing, my lord, suppose it is there, but Supreme Court in so many cases said, reinstatement of the package is not the remedy. My lord, in the decisions I have got my lord's view. So many decisions Supreme Court.
There are also decisions which says, why should you deny him reinstatement? There are other decisions also. There are other decisions which say you can't deny him.
4 decisions, you pay some 25,000 and 2009, 9 decision.
So then you have to pay him compensation lieu thereof.
My lord?
You have to pay him compensation lieu thereof.
Today 50,000, he has already got everything. Only 25,000 I will pay. No problem.
If you pay only this much, then he will definitely not accept it.
He has already received the 17B for
that is because of your attitude, sir. If you had taken him back, he would have not.
No, sir, I will only submit. There is no work after closure of scheme. We had no work to engage them.
For 2 years, you continue to engage him.
Well,
for 2 years, you continue to engage him.
Yes, I don't dispute that. But that is only closure of the scheme.
Right.
The sale centers were closed because of the closure of the government scheme.
Right.
Not because of our business.
How much would be the compensation you would have had to pay? For how long did you work, sir?
My lord, he had already worked 6 years more.
6 years. So you would have had to pay some substantial compensation, 5 lakhs, 6 lakhs. Obviously.
Poor society, they cannot be.
The workmen are not poor, only society is poor.
No. No, the societies, government-run societies, how they run? National societies. All are lost. Permanent loss. Everything they tell, that is lost.
See, all this had to come at the appropriate time. You should have told the labor court, citing all those decisions, that we're prepared to pay this lump sum compensation lieu of reinstatement. You don't do that. You come to the court, you get a stay. Even in this court, in all these years, this has been pending for 12 years, 11 years. You don't make any such offer.
It was listed as a year back.
You could have avoided your 17B. You could have made that offer of lump sum compensation right in the beginning.
But till then, the management did some relaxation because he has already enjoyed the.
This is the whole thing of not taking a realistic approach. Everything has to be contested. Everything has to be fought.
Not that, what the management wanted to have done, because there is no scope to keep them. Because of the closure of the scheme.
All right. There are 2 petitions filed here, one by the workmen, the other by the management. Question the same award. Dated 28th January 2010, passed by the Industrial Tribunal Bhubaneswar in dispute case number 77 of 2008. By the said award, the tribunal has held that the termination of the services of the workmen by the Orissa State Cooperative Marketing Federation Limited, Bhubaneswar, Racket Management, was not in compliance with the requirements of Section 25 Capital F, the Industrial Disputes Act 1947, Racket ID Act. And since the workman had rendered continuous service of more than 240 days, in the year preceding the termination. Accordingly, the management is directed to reinstate the workman and also to pay him lump sum compensation of rupees 20,000. Agreed by the compensation amount and praying for its enhancement, the workman has filed the petition. As far as the management is concerned, it is agreed with the fact that the workman has been asked to be reinstated. This court has heard the submission of Mr. Acharya, counsel for the workman, and Mr. S.K. Patnaik, and the senior counsel for the management. Paragraph. Mr. Acharya points out that in similar circumstances, this court had, by an order dated 24th February 2022, did petition civil 1131 of 2007, Orissa State Cooperative Marketing Federation Limited. This is Loknath Pradhan and another. Upheld a similar award passed by the Labour Court, passed by the tribunal. Paragraph. Reliance is also placed on the decisions in SM Nilachkar versus Telecom District Manager Karnataka, 2003, 4 SCC 27. Haryana State Electronics Development Corporation Limited versus Mamni, MAMNI, AAR 2006 SC 2427. Jagveer Singh versus Haryana State Agricultural Marketing Board, 2009-15 SEC 327. And Assistant Engineer, Rajasthan Development Corporation versus Geetam Singh, 2013-5 SEC 136. Paragraph. On the other hand, Mr. Patnaik, senior counsel for the management, submits that admittedly the petitioner was working in a scheme with the management, which was for a limited duration. According to him, once the scheme came to an end, the employment of the workman could not have been continued. It is in those circumstances that a letter was issued to the workman on 26 April 1993, terminating his services with effect from 30th April 1993. Further submitted and merits that in the judgments of the Supreme Court referred to here and before, reinstatement, compensation in lieu of reinstatement has been accepted as a norm, notwithstanding the fact that the requirements of Section 25 F of the ID Act may not have been complied with. Paragraph. Having considered the submission learned counsel of the parties, the court is of the view that the Impune Award does not call for any interference. Even assuming that the petitioner had been employed under a scheme that had come to an end, the fact remains that even for a period of 2 years after the conclusion of the scheme, in April 1991, the workman was continued to be engaged for another 2 years. Therefore, his employment was clearly not coterminous with the scheme as is sought to be contended by the management in this court. The court finds very little distinguishing features from the decision in Orissa State Cooperative Marketing Federation Limited versus Loknath Pradhan, Supra. Paragraph. As regards the prayer that there should be compensation in lieu of reinstatement, considering that the petitioner is already 58 years old and at best would get only 2 years of service. What's the retirement age, sir?
Return 60 years. 60 years.
To order compensation at this stage does not seem to be practicable. Full stop. Because of the attitude of the management during the pendency of the present petition, the workman could not get back on service and was paid wages under Section 17 capital B of the ID Act, and that too after intervention by this court. The court therefore does not consider it appropriate to interfere with the unibod of the tribunal to order compensation in lieu of reinstatement at this stage. Both writ petitions are accordingly dismissed.
Special list item number 15.
My lord, being apology, my lord, then item number 13, my lord, may be infructuous, my lord. My pleasure.
Okay, 13 is infructuous disposed. All right.
Bless you.
Item 15, my lord. The matter relates to land acquisition. No counter has been filed, and counter is very much necessary.
Not at this stage, sir. Let's see what the matter is about.
Plus the instruction I have received, that is of 3rd March 2011. And it is clear that regarding that minor irrigation project is an additional land of acre 4.12, which is submerged after completion of the construction work. And that is the reason why government has decided to purchase that piece of land. And amount has been sanctioned. And at that stage, particularly in 2011, only plus permission was required to was sought for from the sub collector because these persons belong to the ST, scheduled tribe category. And in the meantime, everything must have been completed, I think. Otherwise, I'll file a counter update with the lordship permit.
No. Have you paid the compensation amount or not?
No.
That instruction I have not received. It is not a now a compensation. Plus, it is not
for the state states that it had been decided to go in for a private purchase.
Yes, private purchase.
Private purchase of the land.
5,54,070.
It has been
However,
decided.
he has no instruction. The counsel petitioner states that the petitioners still have not received any compensation. Mr. Katkia says that he'll file an affidavit at least 1 week prior to the next date, informing the court. There is some counter of 2 and 3. What is that? That doesn't say whether the compensation has been paid. File an affidavit at least 1 week prior to the next date, stating whether in fact compensation has been paid to the petitioners for private purchase of the lands.
It's not a question of compensation to be paid. It has been decided to purchase that piece of land from those persons. It's a private purchase.
It is private purchase, sir.
No.
If compensation is not yet been paid, it should be paid before the next date. List on. July, sir.
Fine. Oblate.
Special list item 16.
None appears dismissible.
Special list item 17.
Lord, may I say, Lord, this matter, my lord, the order of the ombudsman, my lord, under my lord annexure 10 is challenged, my lord. My lord, this opposite party number 2, my lord, he in order to avail is a hotel, my lord, at Puri. My lord, in order to establish a hotel and avail power supply, he independently wanted to install a 100 kV transformer. Then, my lord, he offered his willingness, my lord, by the annexure 1 and 2 series, my lord, that I am ready to install a 100 kV transformer at my own cost, at my place. And, my lord, he was permitted. My lord, he installed the transformer and avail power supply. My lord, annexure 2 series is his willingness application. My lord, may I place this? I am to say that I am giving my willingness to execute the work of construction of 11 kV line and a substation for power supply to the proposed hotel resort unit of Brahmadeva Banijya Case Banijya Care Sipasurwali. Then, my lord, then next page at page 19, my lord, 18, I am to state that I want to take power supply of 70 kilowatt load of my premises at Sipasurwali. I will construct the 11 kV line to my premises along with the 100
kV.
kV.
The other side, you are appearing.
Yes, my lord. I am appearing through BC for opposite part number 2.
What's the current position, sir? Because there is a stay granted by this court.
Yes, my lord. They have not calculated the remunerative amount which the consumer is entitled for refund because of the stay order. May I take the quote to page 30 of the order of the GRF?
Milord, let me.
Page 30, my lord. Because they were not agreed by the GRF's order, so they cannot challenge the order of the ombudsman. Because GRF said
You are not agreeable with the Milord.
No.
Milord, Lord may see the prayer in the order, before the ombudsman, Milord, is to the order of 18.6, Milord. There was no such order of the GRF in 18.6. And the order of GRF, as was prayed for before the ombudsman, that was not quashed, Milord. Ombudsman GRF has said you install the LTCT meter. LTCT meter was installed because, Milord, at the time of installation giving power supply, HTTB meter was not available as per regulation 54.3 and 93.9 of OERC supply code, Milord. LTCT meter was installed. And as directed by the GRF, the HTTB meter was subsequently installed, Milord. And Milord, then he went to ombudsman. Lord may see the ombudsman application. What was his prayer, Milord? Lord may see the application is at a page, Milord. Lord may see page 37, Milord. To set aside the order dated 18/6/2009 of GRF. Milord, there is no such order passed by the GRF, and that is why the ombudsman has not quashed any order of the GRF, Milord, but has given observation that you install the HTTP meter that has been installed, and the ombudsman observation has paid
page 42, sir. 43.
Milord.
42.
Milord.
First line.
Milord. 22.6, Milord. Then you Lord may see everywhere in the body, Milord. It is and in the prayer it is, Milord, 20.
That's such an important point, sir. He has anyway challenged the order of the GRF.
1886. Lord may see what is the order of ombudsman at page 44, Milord. Milord, his case is, Milord, after 2 years of availing that power supply, Milord, once the line has been, even if the line has been constructed by any party, Milord, and it is handed over to SESU, Milord, it became the property of the licensee. That is regulation 17. Lord, for the moment, I may bring to my Lord's attention regulation.
Sir, you go jump from one thing to the other. First, tell us the facts.
Milord, I am telling the fact, Milord. Milord, he offered his willingness. He installed the 100 kV transformer, and Milord, he made a request that the 11 kV line through which I will avail power supply, I want to upgrade it to a higher capacity, Milord. Milord, he was permitted. I was placing, Milord, that annexure 2 series, Milord. He upgraded the 11 kV line of that existing line, Milord. Then, Milord, after 2 years, Milord, he made a request that made a complaint that before the OERC that since you are going to give power supply to other consumers, the money which I have invested should be refunded to us, Milord. Now, Milord, he claims that as per the remunerative scheme, I am entitled to get. Milord, that is something different, Milord.
What did the GRF order, sir?
Milord, GRF order, Lord, may kind of have a glance to page
29.
29, Milord. Milord, 30 is the order. 29, Milord.
The grounds findings.
Milord.
Page 29 bottom.
29 bottom, Milord. Milord, in this regard, the petitioner deposited 6% supervision charges and executed the work at his own request.
Findings on the examination of the endorsed record.
Yes, Milord. Examination record, it is evident that the petitioner is running a resort unit under the banner of registered company named and styled as Brahmandoya Bij Banijya KRs at Sipasuru Valley, Brahmagiri in the district of Puri. The power supply was given to his unit under deposit scheme by the order number so and so dated at Bhubaneswar. His unit availed power supply by the permission letter number so and so of Puri. In this connection, the petitioner has spent more than 11 lakhs, out of which he has spent 2.22 lakhs for converting the existing 3-phase 3-wire 334 mm square AAAC of 15 mm square AAAC near about 2 km. The petitioner alleged that the SESU utility is giving power supply to other private entrepreneurs in the said electric line on commercial basis and collecting the revenue. So he prayed to refund the investment amount for the 11 kV line as he has already incurred in the investment for the said line, Milord. In this regard, the forum is of the view that for execution of 11 kV line, the petitioner deposited 6% supervision charges and executed the work on his own request. And the estimate for the said 11 kV line was done as per Regulation 13 of the Distribution Consumer Supply Code 2004 with reference to Clause 14 of OERC Code 1998. After completion of the above work, the 11 kV line handed over to SESU for maintenance. In this connection, 11 kV line executed by the party is purely the property of SESU, and SESU can extend power supply to other consumers as and when required. If the scheme is found to be remunerative, then the petitioner is eligible to get the amount incurred by him. Regarding the installation of HTTV meter, the metering unit, the respondent stated that at the time of a power supply to his unit, the HTTV meter and the metering unit was not available in the departmental store. So the electricity meter and metering unit was installed in his unit as per the consent of the petitioner. But while conclude the case, this forum direct the respondent to install HTTV meter and metering unit in the petition premises within 60 days. Subsequently, HTTV meter was installed and he avails power supply. Then, Lordship may see Regulation 27. What says, what the forum has observed, Regulation 27 says that the entire service line, notwithstanding that whole or portion of the portion thereof has been paid for by the consumer, shall be the property of the licensee and shall be maintained by the licensee, who shall always have the right to use it for the supply of energy to any other person, unless the line has been provided for the exclusive use of the consumer through any arrangement agreed into writing. This is not the no such a special agreement was done that it is exclusively meant for you. As per this provision, license it became the property of the licensee, and the licensee can give. On mere apprehension, he said that since I have constructed the line, you please refund the line since you are going to supply to other consumers. You Lordship may see, when this is the position, he approached the ombudsman. The ombudsman's order, your Lordship may kindly turn to page 44, on the top paragraph. Last,
it's like a revenue sharing. They say let him get the benefits of this others using the same line.
No, that is not the
investment.
After 2 years of executing the agreement, if at all his grievance
Basically,
is that
it's asking you to share with him the surplus you get. So look at the operative portion, page 45.
45, in the impugned order,
Page 45, Ombudsman's order. In case the gross operating surplus.
Yes, in case the I am reading top, suppose to get the investment cost, in case the gross operating surplus is less than the return of investment on the capacity already invested.
Capital, sir.
Capital
already
capital not legible, that is why capital already invested in the scheme, it is to be shared by both the parties. The respondent shall make investment in the ratio of operating surplus to the estimated ROR, rate of returns, balance capital cost, and capital investment as reduced by the investment made by the respondent shall be the petitioner's contribution. Hence, it is incumbent upon the respondent to determine each of the parties' share after calculating the remunerative scheme, and it is if the investment made by
the remunerative scheme.
What I say, remunerative scheme is something different. Lords may see section 43 speaks that of the Electricity Act, license is obligation to supply power if it is feasible. When the petitioner is establishing a hotel in a distant place, since supply was not feasible, as per Regulation 13, that supplies.
He anyway paid for the laying of the KV line, sir. He paid for the laying of the 11 KV line.
He has upgraded it. He has upgraded it. There was no need to upgrade it. As per his willingness, he has upgraded it.
No, because he has upgraded, you are now using the same line for supplying to others.
That is the law. Once it is, there is not provided in Regulation 27.
If there is a remunerative scheme, why can't you share it with him?
Remunerative scheme is something separate from the very beginning. He could have said that I want to avail power supply under the remunerative scheme. That is not the first from the very beginning. He has objected that. We obtained a permission. If he wanted to that the work is to be done under the remunerative scheme, then he could have challenged the permission order, my lord, as I have annexed, my lord. The scope of work is the deposit scheme, my lord, not the remunerative scheme. Lords may see that document I have annexed, my lord, under annexure. Lords may see that is at page. My lord, have a glance to page annexure 3, page 20, my lord. My lord, the scope of work is, my lord, in the table middle, the scope of work. Then, my lord, right hand side remarks 100 kVA substation 11 by 4.4 substation DP mounted with 9 meters PSC pole number so and so. Then, my lord, the right hand side will remark serial number 1 scope of work is to be executed and maintained by party. Serial number 2, 3, 4, and 5 of the scope of work are to be executed by the party and executed as to be executed by the party and maintained by SESU under 6% supervision charges. My lord, for the purpose of supervision, my lord, only 6% charges are realized from the consumer, my lord. And if it is executed by the party transformer, we have nothing to say. He has to use the transformer. So far line is concerned, my lord, it is to be executed by party and maintained by SESU. SESU is to maintain that line, my lord. And as per regulation, so 1727
has nothing to do with the remunerative model, sir.
My lord, remunerative, have a glance. What is remunerative model, my lord? My lord, remunerative after execution of agreement, availing powers of after 2 years, my lord, he cannot say that it has not been done under the remunerative calculation scheme, my lord.
Why?
My lord, the scheme is deposit scheme. In the scheme table, my lord, I shown it is a deposit scheme. Under the deposit scheme, party has invested the amount. He has deposited 6% supervision charges with the licensee, and he is availing power supply.
The same line you're using to supply others. It's not exclusive to him. Why should he bear the capital cost of laying the line for you? Why should he subsidize you?
Regulation 27 never says that if a line will be maintained by you, you will use it for the
somebody will spend his money, lay the line, and you will use that line to distribute to others.
No, it is nowhere provided in the regulation 17. 27 says, never says that
nothing unfair, sir. There's nothing unfair in the order of this ombudsman. We're not interfering.
Miller, let's see what is this regulation, Miller. Regulation says if the entire service line notwithstanding the whole or part thereof has been paid for by the consumer shall be the property of the licensee and shall be maintained by the licensee, who shall always have the right to use it for the supply of energy to any other person unless the line has been. It is nowhere provided here that if we will make use it for giving power to others.
It's not written into these rules.
At any time he may come. Suppose after 10 years, this line will be
this
used
is not
for
10 years.
benefit of others.
Immediately after laying the line.
After 2 years, after execution of agreement, and after availing power supply for 2 years, in 2009 he filed a case, agreement was executed in 2007, and on this ground, the ombudsman cannot say that he will get this benefit under the remunerative scheme, Let's see what is that remunerative scheme, Scheme is something different, If the feasibility is not there, then he has to wait. We have to obtain clearance from the OERC. OERC is to make a plan, for giving making installation or any transmission line to that, he has to wait, Let's see, regulation 13, says that supply of power shall be made if it is available in the system, technically feasible and remunerative as per norms fixed at Appendix 1 by the Commission, and the applicant enters an agreement in the standard form under Regulation 15, accepting the terms, regulations relating to tariff and other conditions for supply of license. From the very beginning, he could have said so, if it is feasible, then the question of who will say or how much of contribution, it is provided there, In case the scheme of supply is not remunerative, as above, the applicant shall be required to bear the portion of charges to make the scheme remunerative, very beginning, this scheme was not. Very beginning, none of the parties, this scheme was not required to be followed, because of his willingness to execute the work, to install the 100 kV transformer, and to subsequently he made a request that I want to upgrade the 11 kV line, my lord. Then, my lord, it is there provided, my lord, that every distribution, no additional power supply shall be, no, my lord. This remunerative scheme, which your my lords wanted to know, my lord, it is a remunerative scheme, my lord. The scope, the subject of regulation 18 distribution licenses shall give supply of electricity to the premises pursuant to application under clause 4, my lord. Then, my lord, provided in case the application for a new connection where extension of supply requires erection and commissioning of a new 11 kV substation, the distribution licenses shall within 15 days of receipt of application submit to the commission a proposal for erection of 33 kV line substation together with the time required for commissioning the distribution. The commission shall, after hearing the distribution licensee and the consumer concerned, decide on the proposal and the time frame for erection of substation. The distribution licensee shall erect and commission the substation and commence power supply to the applicant within the period approved by the commission. These provisions, these requirements were not required to be complied by that time because of the consumer wanted to do all the works, my lord. Then, my lord, provided that if the substation is meant to extend supply to an individual consumer, the licensee may, unless otherwise directed by the commission, commence erection of substation only after receipt of necessary security deposit from the applicant. Provided further that where such substation is covered in the investment plan approved by the commission, it is if the remunerative question would have been raised by at the relevant point of time, it needs an investment. It could have been covered under an investment plan, an investment could have been made and subject to commission approve that, The commission, the distribution licenses shall complete the erection of such substation within the time specified in the investment plan. Provided that wherever the substation or the line has been covered in the investment plan approved by the commission, the substation, the distribution licenses should not collect any charge from the intending consumer, even though it may not be remunerative. In case the line or substation proposed in the investment plan would have not been there, the distribution licenses shall not be responsible for the delay, if any, in extending power supply if the same is on account of a problem. This is regarding a delay, Subject to above, it shall be the responsibility of the distribution licensee to have necessary commercial arrangements. In case where the village or hamlet area, then Lord may see that under this scheme, the service connection from the name, a consumer can utilize the service connection given to him for the purpose. This is not necessary, Then, my submission is, this was not required because the commission has never taken this issue to be taken up, Because if this issue would have been raised, the matter would have been defended and it would have been proceeded in a different way, Then your lordship's attention may be drawn to section 43, Section 43, lordship may see. It says, duty to supply on a request, Save as otherwise provided in this act, any distribution licensee shall, on application by the owner or occupier of the premises, give supply to electricity to to do that, my lord. Now he cannot come forward after 2 years and say that you please follow this remunerative calculation, my lord. This is not the situation, my lord, and this was not required at the relevant point of time to be followed, my lord. Because if it would have been followed, the matter of consequence would be different, my lord, and he could not have get power supply, my lord, because there was no feasibility in the system of the licensee at the relevant point of time, my lord. And my lord, so far this order of ombudsman is concerned, your lordship may that relevant portion I read, my lord, that ombudsman has said, but subsequently, my lord, this observation, it is against the requirement of law, my lord, and though it was prayed for quashing of that order, that 18.6, no such order was there, and even if the ombudsman has not quashed the order of a GRF, my lord, there is no such order of the ombudsman that the order of a GRF to be quashed, my lord. It is a innocuous prayer, my lord, of the petitioner, my lord, and my lord, my last submission is, my lord, the lord may see this type of a dispute which was raised before the GRF, my lord, and subsequently before the ombudsman, that is not covered. That is the GRF ombudsman are the creatures of statute, my lord, under section 42.5 and 42.6 of the Electricity Act, my lord. My lord, under the provisions of Electricity Act, my lord, 42.5 and 42.6, the GRF is conferred with power to deal with the disputes between the licensee and a consumer, my lord. My lord, what are the proceedings, my lord? My lord, GRF has established under section 42, and by virtue of the circular dated 19th October 2004, my lord, these are the proceedings to be taken up. I am sorry, my lord, only one copy, my lord. By virtue of this circular, my lord, the applicability, the procedure prescribed herein are applicable to the grievance redressal forum insert established by the distribution licensee in the state of Orissa and shall be followed by all forums from the date of issue this circular. Jurisdiction, the forum shall entertain those complaints which are under its territorial and statutory jurisdiction. The forum shall not generally entertain any complaint which under the Electricity Act is required to be disposed of by the authorities like appellate authority, adjudicating officer, electrical inspector, the commission, appellate tribunal for electricity, special court, arbitrator, etc. However, the forum may send back the complaints to the appropriate authority with suitable remarks, if any, subject to the provisions of the Electricity Act, rules, regulations, notifications made thereunder. The forum to defects, deficiencies in electrical services as defined in several irrelevant regulations. Few examples of nature of complaints are illustrated below: new connection, disconnection, reconnection, voltage fluctuation, contract demand, connected load, billing dispute except under assessment under 126, then interruption, metering, classification, reclassification, shifting of service line, connection, diversion of line, shifting of equipment. None of the categories, my lord, as enumerated, my lord, this petition's grievance is coming under none of these scope of complaints, my lord, my lord. My lord, this complaint is without jurisdiction, my lord, and the subsequent approach to ombudsman is also without jurisdiction, my lord.
Yes, sir. Mr. Jena.
Oh, bless me. Let me take a look to page 30 of the writ petition, that is the findings of the GRF. The complainant's claim before the GRF was for refund of the investment made by him.
So GRF said no problem in their using the line for giving electricity to others.
That I accept. I accept. So the last sentence of first para at page 30. So GRF held that if the scheme is found to be remunerative, then the petitioner is eligible to get the amount incurred by him. Licensee did not challenge this finding. My entitlement as held by the GRF. So what the ombudsman has done?
No, why did you go to the ombudsman?
Because there was no specific direction by the GRF. Though the GRF held that if the scheme is found to be remunerative, then the petitioner is eligible. to get the amount incurred by him. But there was no direction to the licensee to calculate it under the remuneration scheme within a specific time and find out if I am entitled for any refund or not. So they, for 1.5 years, they did not comply, my lords, the order of the ombudsman. And only after 1.5 years, when I went to ORC filing a violation petition, then only they approached this honorable court challenging that. After 1.5 years of the order of the ombudsman.
Right.
So ombudsman, what the ombudsman did, ombudsman only made it specific to the licensee to determine it under the remunerative scheme,
Right.
and decide my entitlement accordingly, return it or not. So once they have not challenged the finding of the GRF that I am
That
entitled
they
for
can't challenge, sir. GRF, they can't challenge. No, that's the law itself. The law does not permit them to challenge GRF.
Yes.
they are filing writ petitions challenging the
That's
GRF's
what.
order.
They didn't file writ petition. Yes.
My lords. So they could have challenged it in a writ petition that this observation of the GRF is erroneous or not correct.
Correct.
So they did not challenge. I went to ombudsman for a specific direction to the licensee to calculate it as per the remunerative scheme and decide. So I am placing the impugned order, ombudsman's order, which is at page 44, starts from page 44, last para. I will come to provisions later on, my lords. May I place?
Yes, yes.
So far as remunerative calculation and
You
return
read
of
this already, sir. So this is no need to read it again.
Yes. In the mid, it is written in the instant case, it is evident that no remunerative calculation has been made so far. Admittedly, the consumer has invested the entire amount. So accordingly, at page 45, last 3 lines of the first para, hence it is incumbent upon the respondent to determine each of the parties' share after calculating the remunerative scheme, and if the investment made by the complainant is found to be excess than his share, the same shall be refunded to the complainant by way of adjustment in the next bill. Now, may I place regulation 13, which my learned friend also earlier placed.
Yes.
Section 33 of the Act casts a obligation on the licensee to supply power.
Yes.
So, Regulation 13, subclause 1. The supply of power shall be made.
Sir, his simple point is this.
Before power supply or
You
after?
never applied under the scheme. You never.
I need not apply. They have to, once a consumer applies, that is the law, the regulation. Once a consumer makes an application, they have to see whether the provision of supply is feasible technically or not, whether this supply would be remunerative for them commercially, will be viable or not.
No,
If
he
it
says
is-
there is a remunerative scheme. And
Yes.
You never asked for that scheme to apply.
No, I need not apply. It is their duty to examine in each and every case of new connection to examine whether the investment of licensing will be remunerative or not. Then only they should ask the consumer to bear the portion of the charges of investment or the estimate. So that is why I am placing the regulation 13, the language of regulation 13.
Before traveling power supply, those are the requirements.
Allow me, I have not disturbed you while arguing, so please. So the supply of power shall be made if it is feasible, available in the system, technically feasible, and remunerative as per the norms fixed at Appendix 1 by the Commission. So I have annexed a copy of that remunerative scheme under Appendix 1 as Annexure A by 2 to my counter affidavit, which last may find at page Annexure B by 2 at page 20 of my counter.
Yes.
So I'm reading it out. Introduction. The licensee is under obligation to supply power to the consumer if it is available in the system, technically feasible and remunerative, Regulation 13 of the Code 2004 requires that distribution licensee will look into the technical feasibility and commercial viability as per the norms. In case the scheme of supply is not remunerative as above, the applicant shall be required to bear the portion of charges
So
to
this
make
does
the
not
scheme.
require you to apply.
So, yes, my lord. I need not apply.
Automatically, they have to examine.
Yes, my lord. That is also clear from the subsequent observation. Then the remunerative scheme. An investment on any scheme of power supply shall be treated as remunerative if the revenue from sale of power is equal to or exceeds the cost of power purchase for meeting the consumer's load. Then, last para, any work that does not satisfy the above norms will be taken up by the licensee, provided the consumer bears the differential amounts of capital in cost which satisfies the viability norm. Then they have prescribed the method of calculation of remunerative scheme at page 22. So, if the investment expenditure incurred by the licensee and there is deficit in the investment and return on investment, then the differential cost has to be borne by the consumer, not the entire cost. Because of monopoly status of the licensee, they say once the consumer has invested huge amount in the hotel, there was no choice than to accept they are yet to invest 100% amount. So it is they are due to monopoly status of the license,
Right.
not as a free will.
All right. Okay, here anything more you want to say, sir?
Millard, what my Lord says, friend Neha saying, Millard,
Yes.
he could have said it from the very beginning.
What the
Millard, why I will invest? You please calculate it under the remote scheme. Millard, the license is adopting different schemes, Millard.
Yes.
Millard, the very object, the scheme is, Millard, it is stated under Annex 3 is depositive war scheme, Millard. When
That
he is
scheme must
paying-
satisfy
he is
the
paying
requirement
for,
of
I
law.
want to power supply under the deposit war scheme and I want to invest my own substation, Millard. Millard, when the party applies for supply from the licenses substation, Millard, there only, Millard, license will give an estimate. So this is the shortfall you have to bear, Millard. When party himself has offering his willingness from the very beginning along with the application, Millard, what prevented him not to say that no, I want to avail power supply, you please calculate the remunerative
There's no
scheme.
need for him to say, sir, the scheme requires you to examine it.
Yes.
No, it is not required to be examined, Millard. Lord may say what is his undertaking, Millard, what is his willingness, Millard. Millard, that willingness application I have annexed to the writ petition, Millard.
So he
Millard,
has
Lord-
enclosed the scheme with his counter affidavit. Page
Millard.
20 has enclosed the scheme.
Millard, now after 2 years, Millard, of availing power supply, now he is coming forward, you calculate the scheme, Millard.
All right.
Millard, this is from the very beginning, Millard, when he wanted power supply, if the licensee did not follow the scheme, he could have said that I want to avail power supply under the remunerative calculation scheme, Millard. Then licensee could have proceeded under the said scheme. And when he is saying that I want to avail power supply by installing my 100 kV substation, then Millard, after installing the substation, Millard, he made another request that I may be allowed to replace the existing conductor of a 15 mm square, that whatever size was there, Millard, the 11 kV supply line, he wants that I want to replace it, Millard. Millard, after 2 years, Millard, agreement was executed, Millard, where there is occasion, Millard, or there is any cause of action arises, Millard. You please calculate, go through the remunerative scheme, which was not followed 2 years back, Millard. Is it justified, Millard? It is just an afterthought, Millard. And moreover, it is a money claim, Millard. Millard, what I said, Millard, the GRF has no power to entertain all those things, Millard. This very approach to GRF is without jurisdiction, and it is a money claim, Millard. He could have moved the civil court, Millard, claiming all those claims, Millard.
These are new pleas taken in the writ petition.
No,
You have
not
not
new
taken these pleas before the GRF.
It is common law, Millard. And Millard, after 2 years, Millard, he is claiming this, Millard.
All right. Dismissed, will pass the detailed orders.
Obliged.
Special weekly list item number 18.
Small correction, my lord. My lord, may I permitted to mention a small correction. The item number 14, I have mentioned that he's around 58 years. Actually, he has crossed the 60 years and our date of birth 6/10/1962. So let the matter come tomorrow. For
What is there? Nothing is there.
already crossed the 60 years. 10/1/1922, he has crossed already 60 years.
Ah,
Just now received, my lord.
so he
Just-
can't be reinstated, sir.
My lord,
That's the end of the matter. We don't interfere with the award. He can't be reinstated. That's all. All right.
Matter come up for compensation.
No. That's over. We're agreeing with the award. Yeah.
Not to come tomorrow for
what? No.
For granting compensation.
No. Sorry, sir. Matter is over. Yes.
Special weekly list item number 18.
None appears dismissed on prosecution.
Special weekly list item number 19.
My lord, here the case has been transferred from the chambers of SP Mishra, my lord.
All right. Counsel states that SP Mishra, chambers of Mrs. SP Mishra is no longer handling the matter. Dismissed on prosecution.
Special weekly list item number 20.
Interim orders, if any, are vacated.
Item 20.
None appears dismissed on prosecution.
Special weekly list item 21.
None appears dismissed on prosecution.
Special weekly list item number 22.
All these matters, where we find interim orders?
Special weekly list item 22.
None appears dismissed on prosecution.
And for the opposite party number 3, my appearance may be noted, my lord.
All right.
Good night.
Special weekly list item number 23.
23, my lord. I am party petitioner, my lord. Petitioner, my lord. For the
Opposite party number 2 unserved,
Yes,
sir.
that is.
Opposite party number 2 addressee has gone away.
Yes, sir.
So nothing.
Similar orders maybe. The 4 to 5 cases were disposed of as early as October 2021.
Right. Same order. Are there more matters like this, sir? Are there any more matters?
One more matter, I will check up and I will give the list.
All right.
Special weekly list item number 24.
Members, my lords. The petitioner, my lord, challenged the order passed by the sub-collector directing the Tahsildar to cancel the lease of the petitioner, my lord.
Yes.
The petitioner is an ex-serviceman, got the lease under annexure 10 series, my lord, and 11 is the error issued, my lord. And kindly see the para annexure 1.
Tahsildar's order is appealable, sir.
Tahsildar level directing the Tahsildar to cancel the lease on the ground that it is a surrogate sources. And Tahsildar, what he did, my lord, annexure 11, page to annexure 11, without a notice, he cancelled the deed.
But that's appealable, sir.
No, my lord. Tahsildar don't have any jurisdiction to cancel. He is only rejob. He can only.
What am I asking you?
My lord, he is only can.
What am I asking you, sir?
Whether Tahsildar have right to cancel the deed.
No, my question to you is not that. Just asking the question.
The order.
No, not available.
It's appellable order.
Not available. My lord, can 7 is no, not sorry. My lord, that's correct, my lord. But my lord, appellable, my lord. I'm sorry, my lord. I'm extremely sorry.
Yes.
My lord, directed other day, my lord, that the status, that when the land has been
First of all, you don't understand the question.
I understand.
Then when the question is asked, you answer it wrongly.
No, my lord, bear with him. My lord, bear with him. My lord, the last 11 years, I am before the court. This is honorable court. And a status order has been passed. And this order has been passed wrongly, my lord. That this is surrogate sources. My lord, that's why, my lord, kindly see the last direction given by this honorable court. And accordingly, I submitted the the document that is.
The petitioner, petitioner is now 71-year-old, my lord. He is an ex-serviceman. A sand soil source has been illegally settled in his favor, my lord, possibly in connivance with the government officers, for which it has been cancelled. And what my learned senior is saying with regard to notice has been issued. It has been recorded in the order, my lord. Annexure 3, page 12. Notice to the party duly served and SR back. So he has been heard also.
My lord, kindly see that last order direct.
No, the status quo, meaning Sand Sairat will continue with him for all these years, for 11 years. I mean, this is extraordinary. Some status quo order is passed in 2011. And for 11 years, he has the Sand Sairat source.
No, it's not a Sand Sairat, my lord. Kindly see the last order directing me to produce the record of right, certified copy of the record of right.
No, this is, I think, about cancellation of lease, sir.
Yes, in 2007. And he has challenged in 2011. See page 9.
And status quo was ordered.
Yes, my lord.
Status quo was ordered. So you have been heard, sir.
Millard, kindly see the last order, Millard, directing me to produce the record of right. Millard, I produce that is a flag A, Millard. My lord, direct see whether the observation of the sub-collector is correct. Whether this is the custom of the land. My lord, kindly see that document. I filed my lord, last document 1686. My lord, that is patit. It's never a sand soidat. Neither before nor after. It's never sand soidat. Or any soidat.
Lakshmi, kindly see page.
That's a factually incorrect.
Page 12, Annexure 3, my lord. The case is put up today. Notice to the opposite party duly served on 1/6/2007. SR back. The period of 15 days is over. The party has not yet submitted the pragya.
That is for correction of ROR.
He has also not produced any documents regarding appeal in higher court against the cancellation of army lease by the sub-collector.
So the
And
army lease was cancelled long ago.
Yes, and the subsequent order is not correct the ROR accordingly in government khata. This order is in 2007. He has challenged in 2011. So already 4 years had passed by the time the status quo.
So status quo was meant that it was government ROR.
Yes, government, yes.
Okay. Okay. All right. The challenge in the present petition is to orders passed by the sub-collector on 2nd May 2007. Directing the Tahsildar take steps to cancel the army lease sanction in favor of petitioner in plot 1686 of number 245, comprising an area of AC 0.65 decimal of village Samal, is it?
0.65 decimal.
Is
Village Samal in Kamakya
Yes,
Nagar.
Samal. Yes.
In Kamakya Nagar. Stop. Apparently, there was a permanent Sairat source of cecil over the said land, and the government revenues were being deprived, with the petitioner occupying the land despite the army lease having been already cancelled. Stop. The challenge is also to the consequential orders passed by the Tahsildar cancelling the lease, or corresponding consequential order dated 16th May 2007 of the Tahsildar, 16 May 2007 and 18 June 2007 of the Tahsildar cancelling the lease. The present writ petition was filed only 4 years thereafter, by which time the status quo had already altered, since the ROR was changed to the government. Therefore, when a status quo order was passed by this court on 24 June 2011, the name of the government had already been entered in the ROR paragraph. The impugned orders of the Tahsildar show that the petitioner had duly been put on notice before the said order was passed. However, the petitioner failed to produce the relevant record in that regard. The court sees no reason to interfere. The petition is accordingly dismissed. The interim order stands corrected.
Special Euclid item number 25.
Item number 25, I'm appearing for the petitioner.
Yes.
My lord, kindly see the previous two orders. The previous two orders, my lord, your lordship had directed the state council to produce the records. Your lordship may kindly see order date 23/6/2021 and 39/2021.
Direction has given to us to produce the remand revision case record that is not produced. I think let's may kindly give some more time. I will produce the record.
Mr. Mohanty seeks some more time to produce a relevant record. Two adjournments have already been granted for this purpose. A last opportunity is granted to the state to produce a relevant record. List on 18 July.
Special vehicle list item number 26.
Please, Your Lordship, I'm VC Miller.
Yes, please.
Lord, here the impugn order involves a cancellation of lease under the OGLS Act.
But
although it
you're
was
a bona fide third party purchaser or what?
Yes, my Lord.
So it has to go back.
Yes, no, the sale deed has not been annexed. On which date they have purchased? Yes, sorry. I'm sorry, it is there.
It is there.
Yes.
Yes, ma'am.
A bona fide third party purchaser has questioned the order passed by the impugn order passed by the ADM Bhubaneswar, cancelling the original lease on 1st February 1986, in revision case number 515 of 1983, cancelling the lease. Paragraph. Clearly, the petitioner, which is the subsequent purchaser, had to be heard before such an order could have been passed. On this short ground, the impugn order is set aside, and revision case number 515 of 1983 is restored to the file of the ADM Bhubaneswar. The status quo order passed by this court on 8 July 2011 will continue till such time the revision case is disposed of by the ADM. So the petitioner will appear for the above purpose before the ADM Bhubaneswar, along with a downloaded copy of this order on 9th May 2022. The ADM will pass a fresh order after hearing the petitioner and all others, and any other person who may have an interest in the land in question. And after notices being served on such persons. So the fresh reasoned order be passed within a period of 3 months thereafter. To stop the status quo order passed by this court will continue till the petition is disposed of.
Special vehicle list item 27.
My lord, no instruction, my lord.
All right. No instructions disposed of.
Special vehicle list item 28.
None appears dismissed from opposition.
I'm for the opposite party, my lord.
All right.
Special vehicle list item 29.
It may please your lordship, my lord. The petitioner has challenged
29. I think it's other list, sir. Other list. Special weekly.
My lord, there no instruction on behalf of this country secretary.
Special vehicle list. Special vehicle list item 30.
None appears dismissed from opposition.
Special vehicle list item 31.
None appears dismissed from opposition.
Special weekly list item 32.
Maybe I'm on behalf of.
Speak into the mic, sir.
May please. I'm on behalf of S. Ghosh. Your Honor, he's on the government panel, so kindly be taken.
Whom are you appearing for, sir? You're not audible. You have to speak loudly.
This is that Sukinda matter. Your Lordship has passed judgment, similar matter. Sukinda House. May I please?
This is UN College of Sciences, it says.
But 33.
No, Nabakishwar Mohanta.
Item 33, not
32.
Huh?
I'm appearing in
32.
UN College, Lord.
Nabakishwar Mahanta.
No, Nabakishwar Mohanta, 32.
Yes, he's on the government panel. So kindly be taken on some other date. So we will obtain this.
Which one? 32.
32.
Nabakishwar Mohanta. 24330
Yes.
2011.
2011.
Who is in panel? KR Mahapatra. But this is that covered matter. Your Lordship will appreciate
Sukinda,
that
na?
Sukinda Tahsil.
In fact, all these other people have already come, na? Some of them had already come. This Kageshwar Mahanta, somebody had come.
Yes, ma'am.
is the petition by? Only one of them, only two of them have challenged it. Nabakishore and Phageshwar.
Yes.
I think the others have already challenged it.
Others have already challenged and that is already decided.
Do you have the order?
Just day before yesterday, there was a order pronounced, item number 4 that I just.
And let I pray for some other day it can be taken so that
Counsel for the petitioner stated to have been engaged is now stated in the government panel and time is sought for making alternative arrangements. Learned AGA points out that this is the issue in the present case stands covered by a judgment of this court which he undertakes to produce on the next day. June 21st.
Special weekly list item number 33.
Item 33.
That is 4843. That is 4843 that covered matter. 2010.
2010. 10. Okay. The file
Tarun
of
Kumar
requisition
Rao versus
4843 of 2010 be requisitioned. Item 33.
Item 33, my lord, I am appearing for the.
Lordship, pardon. Item 30 is taken away the file from us. They have taken the consent. Petitioner has taken the consent.
Sir.
Yes, Mr. Mohanty.
Property
Yes.
leased out by the state government. But the short question before your lordship is whether I should pay rent from the date of taking possession or date of sanction. This is the short question before lordship.
Can you repeat the question?
Lord, whether the petitioner is liable to pay rent from the date of sanction order or from the date of execution of the lease and taking possession.
What's the gap between the two, sir?
About 4 years. Kindly sees the lease was sanctioned in 2003, 17/12/2003. Lordship got my date chart?
Yes, yes.
Lord, then Tahsildar calculated the ground rent.
This 11,193 is annual rent.
Yes, Lord. That is the cess and ground rent. Calculated.
No, what is the annual rent work out to?
Annual rent they have not calculated and got.
No, but your challenge you said is whether the rent should be paid from the date of the lease or from the date of.
But they have stated that you pay it from the date of sanction.
Pay it means what? Is there some amount or no amount has been specified?
No. Amount lordship sees annexure. Just 1 second. Yes, that is annexure 2. Annexure 3, my lord, at page 23. It is reported by the revenue inspector Orissa that the land revenue cess in respect of the land leased out in favor of has not yet been disposed since 2004-2005. Lordship marks it 2004-2005. The lease was sanctioned in 2003, but possession was given in 2008 as per
Sir, I'm
the-
still not getting an answer to the question.
Lord, that amount has not been, amount the state must be knowing.
Page
Lord.
15, your lordship can see. Page 15.
1-5.
Yes, ma'am. Clause 1 of the lease deed. Ground rent is 6,396.
No, this is per
So that-
annum or what?
That is per annum.
Sir, for
That is
4
that-
years, what does it work out to? 25,000 rupees.
And it's a college, man.
And you can't pay 25,000 rupees.
Lord, no, Lord, not for that reason. The question is, what is the legal position? Your lordship may kindly visualize this.
Sir, this fantastic legal position will decide in some other case.
Lord,
For 25,000 rupees, we are not going to break our heads in deciding legal position. Your college, sir, what must be the earnings of your college and what is 25,000 rupees for a college? Even your monthly
25,000
fees by a student will be 25,000 rupees.
Lord, your lordship may have that. Your lordship may kindly see page 29. Just for
No,
a
we are
moment.
not deciding like this, sir. Please, this is a high court. We have enough. We have only some, sir, Mr. Monty, we have only 2 lakh cases pending.
Lord,
If you are going to spend times deciding 25,000, 20,000, 15,000, where is the end to this?
No, they have made it.
You
with
may have the
effect-
luxury when we decide against you to even file an SLP against this.
No.
For 25,000 rupees, you're
For
prepared to fight.
for 25,000, your lordship knows the institution will not spend so much of money. That's all. No,
Are you sure it has not already spent a lot of money?
No, Lord, this is a Lord, this institution, Lord, this institution has been built up by that's a separate
Whatever
story.
it is, sir, 25,000 is not worth fighting.
Lord, 2008 is the lease deed. And at page 29, they say that it is to be realized with effect from 2004. And I have given one affidavit that I have kept all the rent in my deposit, in my bank deposit. As and when directed, I will pay.
Better pay it, sir. 25,000 is nothing. You see, given that the annual rent in
No,
terms
till
of the
today,
lease deed dated 30th
till
May
today.
2008 is only rupees 6,396.
Lord,
And
till
the question
today,
is whether the petitioner should be asked to pay rent from the date of sanction of the lease, which is 4 years earlier than the lease deed. The actual amount involved works out to less than rupees 25,000. Less than rupees, yeah, it's around rupees 25,000, which is not substantial at all. Therefore, leaving the question of law open, the court declines to interfere. The interim order stands vacated. The amount stated have been kept in a separate account by the petitioner, now be made over to the state government. The petition is disposed of. Right.
Special weekly list item number 34.
May I please your lordship? In this case, my lord, that this is a relating to cancellation of lease. In the last occasion, your lordship may kindly have glanced order dated 25/4/2018. In this case, my lord, record was called for.
Yes.
But lease was granted way back in the year 1974.
Yes.
But that was cancelled after 14 years, my lord. That is the sole question. To that effect, my lord, judgments have been delivered by this honorable court in 2005-1 Euler, page 1, my lord.
So the reopening was beyond 14 years.
Yes, exactly, my lord. That I have also indicated that proviso, my lord, that page 10 of my brief, my lord.
Correct.
The writ petition suffers from delay and laches, your lordship may kindly see. The impugned order, after 11 years of the impugned order, the petitioner has filed this writ petition, number 1. Number 2, your lordship may kindly see, within 14 years, the process has been initiated and
Within
there is
14
a
years?
fraud. There is a clear...
What's the date of the original lease?
Date of original lease, your lordship may kindly turn to page 28, my lord. 30th August 1974. Page 28.
and 98. The
So
procedure.
this is 30th June, within 14 years, sir.
Yes, my lord. And that your lordship knows
So
that.
this within 14 years.
And that Brundaman Sharma case, your lordship knows Supreme Court has held. If there is a case of fraud, the entire order is honest in the eye of law, so limitation will not stand on the way. That has already been decided. And apart from that, your lordship will find this writ petition was filed after 14 years of the impugned order, 11 years. And there is no.
In this case, my lord, no notice was served. That's why, my lord, record was called for.
No, your lordship may kindly see page 3 of the writ
one day,
petition.
my lord, 1,500 cases have been disposed of by this cyclostyle order, my lord. In none of the cases, my lord, notice has been issued, my lord. And to that, before parting with the merit of the case, my lord, I want to take instruction whether the petitioner is alive or not. So 10 days time may be allowed.
73
By
years
that
in
time,
2011. 11 years, 84.
Again.
No, but
73.
Power of attorney holder, sir.
And apart
Yes.
from that, your lordship
The
has
power of
already
attorney
held
holder is only some 25 years old. So he
that
must very
whether
much
the
be
power
there.
of attorney is still
The
survived because
original lessee is 73 years by that
No,
time.
but
my lord,
represented
the
by a
year
25-year-old.
No, power of attorney is 25 years, but unless the
I'm sure it's all being fought by the power of attorney, sir.
yes, unless
So
unless
he
the
will not let you
executant
give
is
up this
alive, my lord,
litigation so
the
easily.
power, unless the executant is alive, my lord, the power attorney will cease, my lord. That is
if the petitioner is
10
not
days
alive, this
time
power
maybe
of
so
attorney
that
holder has
yesterday I have
no
also tried to
stand.
contact my
And
lord,
he is
but I
73
could not
years
contact
old.
my lord. Only 10 days time.
All right, counsel for the
whether that
petitioner wants
lessee is
to
living.
find out the present status of the original petitioner. First list on 27th April, sir.
Obliged.
Special weekly list item number 35.
May I please, Your Lordship?
Yes, please.
This is against the order of the Lord Tribunal also, Cuttack Bench Cuttack, Annexure 5, page 26, dated 15th September 2011, Your Lordship. Wherein in miscase number, Your Lordship, fact that, Your Lordship, in 1970, he got the certificate of the SC certificate. And in 1971, he appointed as on regular selection process as the LD clerk, Your Lordship. In 1972, is been issued the clarification by the department, by the collector that he will be the SC community, Lordship. Thereafter, 9/6/2003, I made the representation for voluntary retirement, Lordship. Then it has been allowed on with effect from 15/9/2003, Your Lordship. Thereafter, Lordship, on 4th.
We stayed the order of extension of time for completion of inquiry.
Yes, Lordship. Your Lordship,
So today, how old are you, sir? You are already
now
75.
75.
Huh?
75.
Who's for the other side?
They have not given the pensioner benefit. That's
I don't know. Who's for the other
Yes,
side?
yes, my lord. We are there.
What is the point, Mr. Pari?
My lord, here is a small point is that, my lord, in the time of inquiry, he was taken BRS, man. Yes,
So what?
he resigned and go. There was filed in that application, the time of 6 months was extended. Thereafter, inquiry was completed on 23rd 11/2005. That order was challenged before the tribunal, and tribunal confirmed that the extension was correct. Against which they are before my lord.
No. The order under challenge is what dated?
That is 23/11/2005, my lord.
No. 15 September 2011 order is
Sorry,
challenged.
15/11/2011. Sorry. 15/11/2007.
11.
Number 6330 of 2003.
May I submit?
No. MA in the miscellaneous application.
MA is 2677/2005, my lord.
No. 277. 277 of 2005.
2005.
So that MA, the extension was granted. 6 months time was granted in 2011, sir.
Sorry, 277. Sorry, 277.
So on 15 September 2011, you were given 6 more months to complete the inquiry.
Yes, we have completed it.
No,
After
you could not have,
extension,
sir,
after
because
extension, it was
no,
complete.
1 minute. We granted a stay on 12th December, sir. We granted a stay on 12th December of that order. So you can't complete the inquiry.
But inquiry was completed on 23/11/2005.
Then why did you ask for extension?
No, prior to that,
2011 you are still asking for extension.
May praise the matter, Your Lordship. Your Lordship, I came before the one law and tribunal in 6/30 of 2003, Your Lordship.
Yes.
For the given the pensioner benefit and also proceeding concluded the proceedings. Annexure 1, Your Lordship, page 7, 19/1/2005, the Honorable Law and Tribunal held that, Your Lordship, page 21, your Honor, page 14, Your Lordship, page 14, paragraph 10 and 11, Your Lordship, considering the entire facts and circumstances whereof the firm opinion that there is no sufficient justification in putting the disciplinary proceeding to an end in the instant case, we cannot brush aside the matter of such a grave matter, but simultaneously the applicant also cannot be allowed to remain under the domicile's sword of uncertainty. Therefore, a balance has to be struck between the two extremes, and we are required to find some via media so that proper justice can be meted out and imparted to both the parties. 11, Your Lordship, pass the order. In the circumspect of the aforesaid discussion, we come to an irrespective conclusion that the original application deserves to be partly accepted. The respondents are directed to finalize the disciplinary case issued against the applicant by memo dated 4/7/2003 within a period of 4 months from the date of communication of this order.
They didn't complete it.
Your Lordship.
No, so they did not complete within 4 months.
That you not completed. Your Lordship categorically stated, failing which the same shall be treated as dropped and applicant shall be entitled for all consequent benefits.
All right.
However, in the facts and circumstances,
Let me come to our counter page.
make it clear.
1 minute. So they filed that MA.
Your Lordship, make it clear that no further time shall be extended. After 4 months completed, they filed before the tribunal no jurisdiction because May 2/7/2005. Without hearing me, they will extend the time. I came before Your Lordship. I came before Your Lordship. This honorable court was that order and remitted to Annexure 3, page 18.
Remitted to the tribunal.
Taking that, you will decide the matter.
In 2011, they granted 6 more months.
No. Yes, 2011. Prior to that, while they have not any extension has been given, they have issued the punishment order of Annexure 4, page 23, Your Lordship. I have challenged before the tribunal, but they have passed in 23/11/2005. They have not extended the time.
And still they pass this order.
They are after in 2011 passed there, but they have forfeiture of the 100% pension.
Correct.
As well as the
all that is wrong, Mr. Pari.
My Lord,
extension of time, you could not have passed this order.
Lordship, see the paragraph italic I, page 3 of our counter. May I read, my Lord?
Yes.
That the disciplinary proceeding was continuing. The petitioner took voluntary retirement from service from 15/9/2003 and filed an OA number before the Honorable Central Tribunal, Cuttack Bench, Cuttack, to quash the disciplinary proceeding instead of against him. The Honorable Tribunal, by order 9/1/2005, had directed the opposite parties to finalize the disciplinary proceeding initiated against the petitioner by memo number 4/7/2003 within a period of 4 months from the date of communication of the order, failing which the same shall be treated as a drop and the petitioner shall be entitled to for all the consecutive benefits. The Land Tribunal further directed, however, the fact and the circumstances, we make it clear that no further time shall be extended. The order dated 19/1/2005 was received by the opposite party on 2/2/2005. After retirement of the petitioner under Rule 15, inquiry was pending such and such. Thereafter, Lordship complete next page, Lordship. IB. That the miscase para 4 page 4, my Lord, IB. The miscellaneous application at 2/7/2005 was filed by the opposite party before the Central Tribunal, Bench, Cuttack, extension of 6 months time to complete the proceeding. The Honorable Tribunal, by order dated 26/7/2005, was pleased to allow extension of 6 months time up to 2/12/2005 to complete the recent proceeding.
But that order does not survive, sir. We set aside that order and we've sent it back.
But
your order passed in between in November.
Yes.
Inflicting the punishment goes because the order granting extension has been set aside by this court.
Once it was set aside, it goes, but the after extension of the time, order was passed within November.
No, but that extension itself has been set aside, sir.
But thereafter it was challenged before my tribunal, and Law Tribunal observed all this.
After how many years? So the tribunal waits till 2011 and grants you 6 more months.
Yes, that's true. That's true.
And that order has been stayed by this court. So no question chasing this man now.
But the WPC number 10496 of 2000 before the Honorable Court against the order dated 26/7/2005 by the Southern Judge, and that was order dated connecting to the order dated 23/9/2005, my lord, in WPC number 1046.
So it has gone back to the tribunal.
Yes, remitted back.
The tribunal takes only 5 years to decide this one application. That's the whole problem.
Yes, that's the delay is also.
Nobody's in a hurry. Definitely not the tribunal. All right. The challenge in the present petition is to an order passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack CAT, in MA number 277 of 2005, in OA number 630 of 2003, granting the department extension of 6 months for completion of the disciplinary inquiry against the present petitioner. Paragraph: the petition has a checkered history. You say at the outset it requires to be noticed that by an interim order dated 12th December 2011, this court stayed the impugned order of the CAT. Paragraph: the petition has a checkered history. The petitioner started off as a clerk in the Post and Telecom Audit Office, Cuttack, on 3rd November 1971 as a scheduled caste (SC) candidate on the basis of a caste certificate issued by the SDO Kendrapada on 22nd May 1970. Full stop. Apparently, he submitted another caste certificate at the instance of the respondents, issued by the Collector Cuttack on 30th August 1972. Paragraph: the petitioner sought voluntary retirement from service (VRS) with effect from 15th September 2003. Paragraph: 2 months prior thereto, on 4 July 2003, the department framed a charge sheet against the petitioner alleging that he did not belong to the SC and had furnished a false caste certificate. Paragraph: this was challenged by the petitioner by filing OA number 630 of 2003 before the CAT. The said application was disposed of on 19 January 2005, granting the department 4 months' time to conclude the inquiry. Full stop. When the inquiry was not concluded within 4 months, the department filed MA number 277 of 2005, praying for extension of time. This application was decided ex parte, granting the tribunal 6 months' time to finalize the inquiry. Paragraph: since the said order had been passed without hearing the present petitioner, he filed writ petition civil 10469 of 2005 in this court. So by an order dated 23rd September 2005, the tribunal's order dated 26 July 2005 was quashed by this court. MA number 277 of 2005 was remanded to the CAT for a fresh decision. Paragraph: it appears that, unmindful of this development, the department went ahead and passed an order on 23rd November 2005, holding the inflicting the punishment of forfeiture of retirement gratuity and 100% cut in pension of the petitioner. This order was obviously not legally sustainable, since the order of the CAT dated 26 July 2005, granting 6 months extension to the department to complete the inquiry, had itself been set aside by this court. Paragraph. For some reason, the CAT took 6 years to decide MA number 277 of 2005, and by the impugned order dated 15 September 2011, has granted the department 6 more months time to complete the proceedings initiated against the applicant. Paragraph. The effect of the impugned order of the CAT is to legitimize the order dated 23rd November 2005, passed by the department. So, however, for the reasons already explained, that order is unsustainable in law. The petitioner is today over 77 years old, and the court sees little purpose in being served in allowing the department to now hold the inquiry against the petitioner. So stop. That would be not in the interest of justice. Stop. As a result of the impugned order, interim orders passed by this court, there has been no progress in the matter. Stop. Keeping in view all the above factors, the impugned order of the tribunal is hereby quashed. Paragraph. The retirement benefits of the petitioner will now be released to him without any delay, and in any event not later than 1st June 2022. The petition is dismissed in the above terms. Sorry, the petition is allowed in the above terms. Sorry.
Special Wiki List item 36.
My lord, along with me, Mr. Guchat name may be, CGC name may be.
Item 36.
May I please, madam? Since a petitioner, a criminal case was instructed against the petitioner, my lord. Petitioner was arrested, my lord, and subsequently by page 49, final order was passed, my lord, page 49. In the result, the accused is held not guilty of the offence punishable under section 376 IPC, read with section so-and-so and acquitted, and he be set at liberty forthwith, my lord. Since petitioner is a teacher, is an aided educational institution, after the order of acquittal was passed, this order was passed, he submitted his joining report before the institution, my lord. And since his joining report was not accepted, he pursued the inspector school. Inspector school passed an order, my lord, kindly see, that is page page 52. Directing the managing committee, page 52. You reinstate the petitioner since the final order, final judgment has been passed, my lord. Since this was not acted upon by the managing committee, petitioner approached the London State Education Tribunal under section 10A. 10A says, my lord, since an employee of an aided institution cannot be terminated without due procedure, my lord. Since petitioner was not allowed by after the judgment passed, my lord, and not allowing an employee which amounts to termination, my lord, petitioner approached the London Tribunal. After notice was issued, my lord, a counter was filed by the managing committee. Managing committee said before the London Tribunal that after issuance of notice, they started a departmental proceeding. My lord, page 67, my lord, kindly see. May I please, madam?
Yes.
That in view of the above fact, page 67, para 8, the case is not maintainable as prayed for, as the departmental proceeding is pending. It is not possible to allow the applicant to discharge his duty as headmaster. The applicant has been suspended. So, after conclusion of departmental proceeding, necessary order will be passed by the managing committee, and the deponent will be duty bound to carry out. But the proceeding which was according to the managing committee was started page 69.
Yes.
This is after the order of the inspector schools directing the authority to join, allow the petitioner to join. This order was passed, and a counter was filed by the opposite party number 1 and 2, state government, page 76. They said that page 76, annexure 6.
Yes.
Kindly see the paragraph, my lord. Paragraph 11, page 77. That in pursuance to memo number so dated 2/7/2011 of the Commissioner cum Secretary School Mass Education Department, the Inspector Schools Mayurbhanj reinstated Sri Giri as a trained graduate teacher arts at Harish Chandra High School, which is a school of same category by order number so. And here it is pertinent to mention that the headmaster in charge is not a scale bearing the post, and generally senior most TGT teacher is to kept in charge headmaster. Accordingly, my lord, I was reinstated. The order of reinstated, my lord, the past page 87.
Yes.
My prayer before the Law and Tribunal, my lord. I prayed before the Law and Tribunal, page 35. My prayer before the Law and Tribunal, that they humbly prayed that Honorable Tribunal be pleased to declare the applicant to be continuing headmaster of the so-and-so institution with effect from the date of applicant was prevented to discharge duty, and the applicant to be entitled all service benefit for the period from 1st of October 2007 till the applicant is allowed to join and release the salary component. And during pendency of the appeal, state government passed order annexure E to their counter that they have reinstated, my lord. The tribunal passed without considering, tribunal passed order by the page 92, the operating part. Fifth line from bottom, my lord. Paragraph 5.
Yes.
92. After acquittal of the applicant in an offence under section 376 IPC, the Commissioner cum Secretary School and Mass Education Department reinstated and posted him as assistant teacher in Harish Chandra High School, as per the statement in para 11 in the counter right annexure D/1. And the area salary of the applicant have been released with effect from 1/10/2007 as per annexure B/1. Therefore, in view of the aforesaid order, satisfying the claim of the petitioner, he has got no case. In this background, the case has become infructuous dispute by kindly see annexure B/1, which was relied by Law and Tribunal. Annexure B/1. That is at page 82. Page 82, my lord, can you see the last part memo. Salaries, may I permit? Page 82, my lord. The
Yes,
B/1 state government.
Yes, we have it.
May I permit, ma'am?
Yes, please.
The memo, my lord. Office of the information that necessary action, the salary of the Ramachandragiri headmaster of so-and-so institution be paid for the period 1/10/2007 to 20th March 2009 as per the order of the Honorable Tribunal. Though my lord, though my case was disposed of in 2011, till that date I was not receiving my salary, and the commissioner has said that I was reinstated, and I have already been reinstated, my lord. But without being salary for the period, only the salary tribunal took note of that from 2007 to 2009. And tribunals come to a conclusion that applicant released got the benefit with effect from 7 till date, my lord. Now I'm continuing, my lord. I am reinstated, but without my salary, that period has not yet been released, my lord.
But that was the period during which the acquittal had not taken.
That was in 2008, my lord. Acquittal 2008.
So this is post-acquittal period.
My lord, that is why, because after acquittal, I submitted my joining report. That was not accepted by the managing committee. I prefer an appeal, my lord, saying that not allowing me is amounts to termination. Tribunal took note of that. Notice was issued. Managing committee at the time of hearing said, no, we have started a departmental proceeding. And government said, no, we have reinstated. In the way, and tribunal disposal, since we have been reinstated, matter become infructuous. And so far as I have been reinstated, my lord. So far as my salary and that period was not discussed by tribunal, my lord.
Who's for the other side?
Yes, my lord, I am for.
Yes, Mr. Mahmood.
My lord, we have filed the counter in this writ petition also.
Yes.
My lord, it is a fact that after order of acquittal was passed,
yes,
the inspector has issued necessary instruction for reinstatement.
Yes.
That being not done, so the instruction was sought for from the government and government directed to reinstate him in any other school because of the disturbance caused at the school where he was working prior to his arrest. And therefore, as a special case, he was reinstated. And so far the payment of salary is concerned, as communicated by the inspector of schools, the period from 1/10/2007 to 23/2009 has been paid. But so far the 21/3/2009 till his reinstatement or joining in his new school, since he was not worked, so the salary was not paid. This is the counter of
You
the.
didn't allow him to join, sir. So where's the question of if you don't allow him to join, how can he work?
No, my lord, so far the question on behalf of the opposite party, I mean, the state government is concerned, all steps have been taken that he should be reinstated. Accordingly, an order was passed to reinstate him
Why would sir, if he is prevented from joining, why should he be punished for that?
Oh, that is for the managing committee, my lord. So far the government is concerned.
This is a government school.
Aided school.
Aided school.
Aided institution. Subsequently, it was taken over. Now it is taken over, but it was then as an aided institution. But the government has taken the order of the spirit of the Honorable State Education Tribunal, and accordingly to pass an order that instead of hampering on the particular school, he should be reinstated in any other school because
either way, sir, whether it's at that school or any other school, he still has to be given his salary for the period he was supposed to start working.
Yes, that is.
That's the only short point here. All right. The present petition involves the present petition. It seeks the quashing of an order dated 15 September 2011, the State Educational Tribunal, in appeal case number 22 of 2009, involves a very short question. Namely, whether the petitioner is entitled to arrears of salary from 21st March 2009 till the date of his reinstatement in his post of teacher, right?
Assistant teacher, ma'am.
Assistant teacher at the?
Yes, assistant teacher, junior assist.
Junior assistant teacher of the Banastali Vidyapitha at Mayurvansh.
May I intervene?
Yes, please.
He was reinstated in Harishchandra. Suspended from that Banastali and reinstated in Harishchandra school by order of the government. That you not mean.
Harishchandra what?
Harishchandrapur Aided High School, page 87.
At the Harishchandrapur Aided High School.
My.
At the relevant time, Banastali Vidyapitha Badjod was an aided educational institution within the meaning of section 3 bracket small b of the Orissa Education Act bracket OE Act. Full stop. The petitioner was appointed as the headmaster of the said school on 5th April 1990. Case was initiated against the petitioner. A criminal case was instituted against the petitioner for the offence under section 376 IPC, read with section 3 of the SC and ST Prevention of Atrocities bracket Act. Full stop. The petitioner was taken into custody. Full stop. He was paragraph. The petitioner faced criminal trial under trial case number 17 of 2008. Full stop. The sessions judge Mayurbanj Baribada by an order dated 27th December 2008, honorably acquitted the petitioner. In other words, he was found not guilty of the offences with which he was charged. Paragraph. The petitioner then reported to the managing committee of the school in question to allow him to resume duties in the same post. However, the governing body of the said institution asked the petitioner to approach the inspector of schools. Stop. Paragraph. On 13th January 2009, the inspector of schools intimated the president of the managing committee of the said school to pass immediate orders to reinstate the petitioner in service and to pay him the salary during the entire period of suspension by treating the period of suspension as spent on duty. Paragraph. Despite the above order, the petitioner's joining report was not accepted, leading the petitioner to again approach the inspector of schools. Paragraph. The IOS, for the second time, sent a letter dated 21st December 2009, asking the president of the governing body of the school to allow the petitioner to be reinstated in service. Paragraph. With these attempts failing, the petitioner approached the SET under Section 10 capital A of the OE Act, stating that preventing the petitioner from resuming duties amounted to termination of his service, illegal termination of his service. Stop. By the impugned order dated 15 September 2011, the tribunal has held that the petitioner was not shown to have been appointed as a regular headmaster. He was reinstated as assistant teacher in the Harishchandra High School, and arrears of his salary had been released with effect from 1st October 2007. With these observations, the application was dismissed on the ground that the case of the appellant had become infructuous, and that since his claims had stood satisfied, open quotation, he has got no case, unquote. This court has heard submissions of Mr. Durgesh Pratham, learned counsel appearing for the petitioner, and Mr. Mahapatra, learned counsel. Deepthi Ranjan Mahapatra, learned additional standing counsel for the
Standing counsel.
Standing counsel for the Higher Education Department.
School and
Mass Education Department. Paragraph. In the impugned order, the tribunal appears to have missed the point sought to be made by the petitioner, namely that he was prevented from joining the post by the department, by the school in question. And for the period when he was prevented from joining, he could not be deprived of the arrears of salary. So what was paid to the petitioner, as noted by the tribunal, is the salary released for the period from 1/10/2007 till
23/2009.
23/2009. the admitted position is that the petitioner was finally reinstated only on
5/7/2011.
July 2011. Full stop. Therefore, there was still a gap during which the arrears of salary of the petitioner was required to be paid. Full stop. There is no reasonable explanation offered by the department except by saying that it is the school in question that has to pay that amount. So, however, admittedly, the school in question has been taken over by the government. And therefore, the liability would fall on the government only. Paragraph, for the aforementioned reasons, the impugned order of the tribunal is set aside and a direction is issued to the SNME department to pay the petitioner the arrears of salary for the period between
21st 2000 March 2009 to
31st March 2009 to 5th June 2011, 5th July 2011.
July.
The amount we paid now within a period of 8 weeks from today, failing which the department will be liable to pay the petitioner simple interest at 6% per annum on the said amount for the period of till the date of payment. All right. The petition is disposed of in the above terms.
Special list item number 37.
Can it be 3 months? Can it be within 3 months?
So it's not a substantial sum, so 8 weeks, it should be more than enough.
Right.
Item 37. 37.
Item 37, Your Lordship, I'm appearing through virtual mode. Your Lordship, the petitioner has already attained the age of superannuation, though the petition is virtually infructuous.
All right. Counsel the petitioner states that since the petitioner is superannuated, the petition has been rendered infructuous. It is disposed of as such.
Special list item 38.
On behalf of Mr. Bikanak, no instruction.
No instructions disposed of.
Special list item 39.
May I please, Your Lordship? Your Lordship, may kind of annexure to page 14. Page 14, annexure 2. Lordship, the second memo, that is memo number 47082. May I please, madam?
Yes.
Memo number 47082, Sri Samarendra Pradhan, that is the applicant, Inspector of Police, was allowed to officiate as DSP in OPS cadre on ad hoc basis and posted as Security Officer Utkal University, Bhubaneswar, in Home Department notification number so-and-so dated so-and-so, is reverted to the post of Inspector of Police in consultation with Orissa Public Service Commission, Cuttack, with immediate effect. Well, by virtue of this order, the applicant was reverted from the post of DSP to the post of. This was the subject matter of challenge by the applicant before the Land Tribunal, that is in OA number 2289 of 1996. And after considering the pleadings, the Land Tribunal had order dated 23/9/1996, my lord, directed for stay of this order. Now, my lord, we can see next page, page 15, annexure 3.
Yes.
Well, while this interim order was in operation, my lord, the applicant withdrew the original application. Paragraph 2 of the order, Your Lordship, can see the Land Counsel for the applicant files a memo for withdrawal of this original application on the ground that the applicant has already been retired and does not want to prosecute the case in view of the paid memo. The OA is permitted to be withdrawn with no liberty to agitate the same cause of action. Therefore, any bench of the tribunal, the OA is disposed of. So the order directing page 15.
What's the date?
One, just a minute.
Not readable, that's why.
Yes, that is
21st
1/2/2003. 1/2/2003.
No. 21st February 2003.
No, 21/2/2003.
2003.
Yes. 21/2/2003.
All right.
Now you Lordship may kindly see next page. Now, since the order directing reversion from the post of DSP to inspector has attained finality, so we accordingly fixed the pensionary benefits of the post of inspector of police. And this annexure 4 was challenged before the land tribunal by the applicant, and under annexure 5, the land tribunal has set aside that order and directed to give the pensionary benefits of the post attached to the post of DSP. And the issue is no more res integra. This issue has already been settled by the Honorable Apex Court in 2008, volume 17 SCC, page 73.
Sir, have you served the other side?
No, they have already entered appearance.
Anyone appearing?
Yes, my lord. I am appearing for the opposite party.
Your Lordship can see this judgment, paragraph 3. The appellant filed a writ petition before the Allahabad High Court seeking a direction to the respondents to call him for interview for the post of medical officer Ayurved Unani. In the said petition, an order was granted on 31/10/2007, permitting him to appear in such interview. By making use of the said interim order, he secured an order from the Board of Indian Medicine UP, restoring his enrollment from the date of initial registration. Consequently, he was called for the interview there. Thereafter, he moved the court for dismissal of the writ petition as not pressed. The High Court on 25/2/2008 accordingly dismissed the writ petition by the following order. Now, your Lordship can see paragraph 5. Paragraph 4. The appellant is aggrieved by the observation.
So what you're saying is once he withdrew the writ petition, his reversion became final and his pension had to be fixed only as
on the reverted post.
Yeah.
That is the post of inspector.
Inspector and not as DSP.
Yes. Now the land tribunal has directed, no, he is entitled to get the
pension as DSP.
Yes.
So who's the other side? Yes. What do you say, sir?
My lord, as the interim orders were passed, I was continuing the post of DSP, my lord. But
But you withdrew the writ petition, sir.
After my retirement, my lord, after my retirement only, I withdrew the
But then that became, your reversion became final.
That is true, my lord.
All right. The challenge in the present petition by the state is to an order dated 3rd September 2009 passed by the Orissa Administrative Tribunal in OA number 877 bracket C of 2004, filed by the opposite party. Number 1. And directing that this pension, retirement and pension benefit should be recalculated as if the respondent had opposite party number 1 had continued in the post of in the rank of Deputy Superintendent of Police, bracket DSP, till the date of his retirement. Paragraph. The background facts are that opposite party number 1 was selected in 1992 for promotion to the rank of DSP from the post of Inspector of Police. He was allowed to hold the office of DSP as ad hoc DSP by notification dated 29 January 1993 till the date of recommendation made by the Orissa Public Service Commission, bracket OPSC, bracket Kamak. Paragraph. Within the stipulated period of 1 year, the OPSC did not recommend the case of opposite party number 1. Full stop. His posting as DSP was therefore extended. Subsequently, by letter dated 23rd February 1996, the OPSC did not find the opposite party number 1 suitable for promotion to the rank of DSP. Full stop. Accordingly, by notification dated 31st August 1996, the government reverted the petitioner from the post of DSP to the post of Inspector of Police. Paragraph. The above reversion order was challenged by the petitioner, by the opposite party number 1, by filing OA number 2289 of 1996 in the OET. Full stop. While issuing notice in the said application, the OET stayed the operation of the notification dated 31st August 1996 by an order dated 23rd September 1996. Paragraph. As a result of the above stay order, opposite party number 1 continued as ad hoc DSP till the date of his retirement, that is 31st March 2000. Paragraph. It appears that when OA number 2289 of 1996 was listed before the OAT for hearing on 21st February 2003, opposite party number 1 informed the OAT that since he had retired from government service, he did not want to prosecute the case. Full stop. The order passed by the OAT on 21st February 2003 in this regard is significant and reads as under. Specifically, it was stated, reproduce the order, and then you say it may be noted here that the permission to withdraw the petition was without liberty to agitate the same cause of action. Full stop. Consequently, as a result of withdrawal of the above writ petition, the petitioner's reversion from the post of DSP to that of Inspector of Police by the notification dated 31st August 1996 of the government, became final. Paragraph. It is thereafter that an order was issued on 9th May 2003 by the Home Department, Government of Orissa, fixing his retired dues and pension on the basis that he had been reverted as Inspector of Police after 31st August 1996. Full stop. Paragraph. The above order was challenged by the opposite party number 1 before the OAT by filing 877 OA 877 bracket C of 2004. Full stop. By the impugned order dated 3rd September 2009. The application was allowed by the OAT, and a direction as noticed herein before was issued to the department. It will be noticed here that by the order dated 22nd January 2015, notice was issued by this court the present petition. Subsequently, on 28th March 2019, while admitting the petition, the impugned order of the OAT was stayed by this court. Full stop. However, it was made clear that the opposite party number 1 would be paid his pension as inspector pending disposal of the writ petition. This court has heard the submissions of Mr. P.K. Mudali, learned counsel for the petitioner, and Mr. Amrit Mishra, learned counsel appearing for the opposite party number 1. Paragraph. Mr. Mudali placed reliance on the decision of the Supreme Court in Abhimanyu Ram versus State of Uttar Pradesh, 2008-17 SCC 73 to urge that with the withdrawal of the writ petition unconditionally by the petitioner, by the opposite party number 1, challenging his reversion from the rank from the post of DSP to that of Inspector of Police, the said reversion became final. Consequently, on the date of his retirement, that is 28th February 2003. What is the date of the retirement? Sorry, 31st March 2000. The petitioner could have retired only as inspector. Full stop. It so happened that on account of the stay granted by the OAT, he retired as DSP. But with the writ petition itself standing, with the application itself standing withdrawn without any liberty, the retirement of the opposite party number 1 could not have been in the rank of DSP, but only in the rank of inspector. To the same effect is the decision of the Supreme Court in Abhimanyu Ram versus State of UP Supra paragraph. Consequently, the court has no hesitation setting aside the impugned order of the OAT and directing that the opposite party number 1 will be continued to be paid his pension and other retirement benefits in light of the order dated 9th May 2003 of the Home Department.
No, that you also can see that 9 May 2003 order, but there are 3 directions. And the Supra direction 2 is concerned, you Lordship may consider, because there we have held that since he was reverted from 31st of August 1996, so he is not entitled to get the post of salary of DSP, because by virtue of order, interim order, since he has discharged.
Work till, yeah. So
that you Lordship may consider.
Will be paid subject to the modification that the petitioner will continue to get salary of DSP for the period after 31st August 1996 till the date he retired, because he continued working as DSP till the date of his retirement. In other words, he'll get salary of DSP for the period, also for the period between 31st August 1996 till 31st March 2000. The petition is disposed of in the above.
Oblige, my lord.
Yeah, after.
My lord, may I be excused, my lord? Item 46 permitted to be withdrawn with liberty to file this suit.
That Sukinda matter, Tosri.
This is withdrawn?
Withdrawn to file suit.
With liberty to file civil
suit. Counsel, the petitioner seeks leave to withdraw this writ petition with liberty to file a civil suit in accordance with law without expressing any view on whether such course of action is permissible. The writ petition is disposed of is withdrawn with liberty.
44, 45 also withdrawn.
44, 45, same order. All right.
Special weekly list, item number 40.
I'm from Chennai, my lords. May I make a humble submission, lords?
Yes, of course.
Yes, my lords. My name is Venkat Shivkumar, my lords. I'm a chartered accountant.
You are the insolvency professional.
Yes, my lords.
Correct,
what happened, lordships have passed one order wherein it is a matter concerning a sales tax review, my lords. And 100 lakhs we have paid, and your lordship was kind enough to allow that. And we got it, you gave 8 weeks time, lordships, to ensure the matter is done. Then we went into that assessing officer, joint commissioner, and got the assessment order done, and 99 lakhs of rupees is to be refundable to the liquidator. And they are not, this is in October, they were not refunding everything. Thereafter, I moved a petition before Honorable NCLT Chennai bench, and the matter came up for hearing last Friday, my lords. The commissioner representing says that we have filed one more review before Chief Justice Court. Therefore, we are not willing. Actually, 33.5, the moratorium is there for us, and no proceedings are maintainable.
What's the number of that? What is the number?
ST number 6 of 2005, my lords. STEV 6, STREV 25, STREV 26. 3 review petitions, my lords.
All of 2005?
Yes, my lords. 2005, 2010, 2010.
Oh.
Yes.
Which is 2010, sir? 25 and 26?
2000, yes, my lords. That is, yes, 25 and 26, my lords.
All right. Who's for the department? Usually there's a Sanjay Mishra, Sunil Mishra, sorry. He's not here. We listed day after.
Much obliged. They have not made liquidator a party, my lord. That is the problem.
I know.
We also
Because
don't know.
these are old matters, sir. So they will not
Yes.
know.
Yes, my
So we
lord.
listed day after.
Much obliged, lords. Thank you, my lords. Thank you.
All right.
Much obliged. So nice.
Special weekly list item number 40.
None appears.
Yeah, I am for the opposite party.
All right. Good. This is not.
Special weekly list item 41.
None appears. This was not possible.
Special weekly list item 42.
May it please, my lords.
Yes.
My lords, a short point for consideration before your lordship is whether uncommunicated adverse remarks can be utilized to debar me from promotion. That's a short point for consideration before my lord. My lord,
No, sir. You've not served opposite party number 2.
I've served.
No. They've still date not been served.
Oh, on 26/12/2011, I served. Oh, okay, I'll serve, my lord. If my lord will say, I'll serve, my lord.
No, but tell us what the matter is about, sir.
Matter is.
No, what does the tribunal say?
Tribunal, my lord, may kindly give me 5 minutes. My lord, may kindly come to page 17, my lord. My lord, I was not given promotion. That's why I filed a petition and the tribunal, page 70, page 17, my lord. The last portion. We therefore direct the promotional case of applicant at that point of time to OFS 2 should be reconsidered within reference to available CR, and for that period excluding the one of 80-81 with a fresh view to taken to review DPC. So the order was passed for convening a review DPC, my lord. My lord, then come to.
So you're now retired, only your pension will get reworked.
Yes, my lord.
You're already 68 or 70 years old.
Yes, my only pension will be revised. And my only case is that uncommunicated adverse remarks were utilized against me for not giving promotion, where my juniors were given promotion, my lord.
So review DPC has to be held. It was never held.
Review DPC has already convened, and they did not take it to my case into consideration, and they, without assigning any reasons, they said that the applicant will not be entitled for promotion.
Where is that?
My lord, before that, the order which is subject matter of challenge in this petition, my lord, may I just take only 2 to 3 minutes. I'll just convince my lordship. May kindly come to page 24. Just 2 to 3 minutes, my lord. And in 86, my case was considered. The committee, after going through the service particulars and CCRs of general forest rangers, found the forest rangers suitable for promotion to the rank of OPS class 2. My name finds place at serial number 40 on the next page, page 25.
Yes.
My lord, at page 29, what it might be termed as negative equality, my lord, but one Pramod Kumar Pradhan, who was junior to me at 67, in page 29, I have stated this. He has got adverse remarks in his CCR for the year 83-84. He has committed financial irregularities and neglected. He is not reliable. My lord, he was given promotion. But I was not given, although the government said I was eligible for promotion. And basing on that, the opposite party number 3 in annexure 3, they gave promotion without taking my case into consideration. And the tribunal, my lord, the order
61, page 61.
If it starts at page 61, the last portion of the order, at page 66. the last page 60, the review DPC came to a conclusion that the applicant was not suitable for promotion from the date his juniors got promotion after DPC meeting on 31/1986. My lord, I had shown, my lord, that 31/1986 annexure 2 letter wherein the government has recommended my case for promotion, but the OPSC had not recommended my case for promotion. That is my only case. And all those CCRs, the Gopi said that as because that adverse CCRs were against me, and so that's why my case could not be considered. But all those adverse CCRs were not communicated to me. And was as per Devdutt Patnaik's case in
that part is over. You see the part where you said, because there are two orders. After 11th September 2009, they held a DPC, correct?
Yes, my lord.
What is the DPC held after 11th September 2009?
Only they said that, my lord, that he is not eligible without assigning any reason. Page 34, annexure 4. Page 35, they said that therefore the prayer of the applicant for allowing promotion to the rank of ACF class 2.
This DPC did not take into account the adverse CCRs, correct? The uncommunicated CCRs.
My lord.
So even if you keep the uncommunicated CCRs aside,
I was not given promotion.
That's right. So we don't know what are your gradings for the remaining. You see, there are adverse CCRs, non-adverse CCRs.
My lord.
But promotion is not a matter of right. So
yes, I completely agree to what my lords are saying, but my only endeavor here before my lord is, if the adverse CCR were not communicated to me, it cannot be taken into consideration for not granting me promotion when my juniors were given promotions.
No.
Second,
so that one ground is over now because they've held a review DPC, keeping aside the uncommunicated CCRs. They've not taken it into account.
So that my lord, they have not assigned any reason why they have not taken that thing into account. They just, page 34, they just said that we are not finding you eligible.
Have they filed a counter affidavit?
No, my lord.
The same problems every time. No counter is filed for 10 years and 11 years.
Well, our record shows that notice has not been issued.
What is this, sir? You are there anyway.
Okay, Lord, may kind turn to page 65. Part of the impugned order. Page 65, subparagraph, my lord.
Yes.
In compliance with this order, the respondents had called for a review DPC meeting on 15/4/2010 to consider the case of promotion of the applicant to the rank of SCF2 retrospectively. On the basis of the recommendation of the DPC, the office order dated 22/4/2010 was issued. It was ordered that the prayer of the applicant for promotion to the rank of SCF2 from the date his juniors were promoted has no merit and the same was rejected. Now, this is important. The respondents had submitted copies of the proceedings of the review DPC held on 15/4/2010. We have perused the same. We find that the DPC, after consideration of CCRs for the period from 81-82 to 1984-85, found the applicant not suitable for promotion to the rank of SCF in OFS 2. The said review DPC had considered the case of the applicant along with another forest range officer and formulated their recommendations. We are of the view that the DPC had adopted the appropriate procedure for considering the case of the applicant and took into account the CRs for the relevant period, excluding the CCR of 1980-81.
So that was the adverse one. 80-81 must have been the adverse one. They kept it aside.
Yes. The learned tribunal are perused all the records.
See, the only ground he's making out is he not given reasons why you did not find him suitable.
Now
there's no obligation to give reasons.
Now the learned tribunal has, after perusal of the records, has given a detailed reasoning.
And another thing, my lord may come to page 37, annexure 5. They have taken, if what my learned senior is saying, if 81 year CCR was not taken and an average officer good 84-85, that is an average officer good. So as per the DA department, my lord,
if it's an average, then you can't say that you are entitled to one promotion, please.
My lord, that is what is given here, my lord. I'll show the annexure 6, my lord. The average CCR, page 39, my lord. Average CCR 14.4, my lord. The last portion. General remark, like this is the book circular number 48 on which the CCRs are given, my lord. The general remark like work satisfactory and average option would not counterbalance adverse remarks. This is crystal clear, my lord. So these cannot be taken into consideration for not granting me promotion, my lord. And moreover, my lord, I have filed RTI applications for why my case was not considered, and all in the RTI application they have said that no, it's not there. The CCR is not there for consideration.
No, the 8081 CCR is not there, sir, because that has to be kept out.
My lord, may come to annexure 9 and annexure 10, my lord. The RTI application which I had filed. Page 56, my lord. 23/5/2011.
Yes.
Information pertaining the year 1981, 82, 83, 84, 85 is not available in this office. On the what basis they have made the grading and done this is.
So only 83, 84 they have. They have only 83, 84.
Only that's the only thing. And I concede to my what my learned senior was stating. I've already retired, my lord. I'll only get few financial benefits if I win in this case. That's the only thing. And
so how did the tribunal see something which is not available in the office?
No, that was might be it was produced later on. So that's after perusal of the records, this finding is there.
No.
The
How they
records
say
are
that
produced.
record doesn't exist?
No, records were produced. Right?
Then how does this reply? How do you reconcile with this reply? Information. This is given in 2011. Whereas the order of the tribunal is
same year, November 2011. This is May.
This is Acha. May 2011 is the other order. I mean, is the tribunal's order. The RTI reply is November 2011, is it? May 2011. So between May and November, they may have been able to locate the record. That's the only inference to draw because we can't doubt the tribunal.
No. Your Lordship, what was the question, Your Lordship? Page 54. What was the information sought for? Page 54. Serial 5.
Whether the adverse remarks, there is no such adverse remarks between those years.
No, adverse remarks were communicated to him or not?
No. So yes. 81 to 82, he's trying to draw the inference that there was no adverse remarks in those years. 80, 81 is adverse remarks, so it has been kept aside.
Yes.
Anyway, you say this is the second round of litigation. We're not inclined, sir, to interfere.
My lord, let them file counter. With
No, it's okay.
Tribunal, my lord, may come to the last paragraph of the tribunal judgment. Last paragraph. The review DPC came to a conclusion the applicant was not suitable for promotion from the date his juniors got promotion after DPC meeting on so and so. DPC is entitled to come to its conclusion reference to records and parameters for promotion in rules and orders. Thus, the order of this tribunal in 653 of 99 having been complied with. So, my lord, in 653 of 99, there was a stipulation that please convene a review DPC, and if the applicant is found suitable, give him promotion. And no reasons were given. When I have showed, my lord, in 1986, I was eligible for promotion. My case was considered for promotion. The government gave it to the OPIC. I showed, my lord. But the OPIC, out of his own wisdom, with due respect, did not consider my case. So that is why I came again to the tribunal. That is my predicament, my lord. And the GS department circular on which the CCRs are looked upon, my lord, they also state that average cannot be given. And any entry, it's not, and Devdutt Patnaik case, my lord, it's crystal clear that any entry in the CCR has to be communicated. So nothing has been communicated to me, my lord. And on what basis they have?
Adverse entries have to be communicated, sir.
Not only, my lord, just
no,
one minute.
How do we know? You're also making a presumption that there were adverse entries.
No, any communication.
You're also making a converse presumption that if there are no adverse entries, I should have got promotion.
No, if at all there is I'm conversing. What my lord is saying is true. If there is no adverse entry, then I am eligible for promotion. Tribunal said
eligible for promotion, sir. But
that's why when my juniors have been given, no proceeding were pending against me on the date when the DPC was held. So they could not have kept my case in seal cover. The government, my lord, I am showing this thing. This annexure, the proceeding of the DPC meeting, my lord, annexure 2. The relevant page is page 24. May I place, my lord?
Yes.
Page 24. The committee then, after going through the service particular and CCS of the General Forest Rangers, found the following rangers suitable for promotion to the rank of OFS class 2. My name comes placed at page 25, serial number 40. DPC considered my case for promotion. The OPSC, my lord, they didn't consider my case. And then when I went to the tribunal considered, and they told that a review DPC will be at, and in the review DPC, page 34, no reasons have been assigned as to why.
Yeah. And
that my lord may see the Devdutt Patnaik case, which is reported in A 2008 SC 2513. May I place, my lord?
Yes, please.
Well, just two paragraphs.
Yes, read on.
Fairness and transparency in public administration requires that all entries, whether poor, fair, average, good, or very good, in the ACR of a public servant, whether in civil, judicial, police, or any other state service, must be communicated to him within a reasonable period so that he can make a represent for his upgradation. This rule will not apply to military officers, that's okay. The nomenclature of entry is not relevant. It is the effect which the entry is having which determines whether it is an adverse entry or not.
So the scope of your petition is one prayer in your petition that the ACR should be communicated?
No, as because my ACRs were not communicated, that is why they have not given promotion, my lord.
No. Let's be clear now.
My lord.
Was your prayer before the tribunal that the ACR should be communicated on the strength of the Supreme Court? It was not.
No.
So we can't change the scope of the petition. So that is not the scope of your petition.
What was my prayer before the tribunal, my lord? Page 40.
You wanted your promotion. You said the same day my junior got promotion, I should get promotion.
My lord.
That was your prayer.
Page 40, my lord.
Yes.
In page 45, this is the prayer.
Yes.
Last program. Was the recommendation of review DPC held on 15/4/2010. The recommendation not granting me promotion and rejection without assigning any reasons.
So it's not about communication, non-communication of CCRs. It's not about that.
Communication, if it would have been
So no, this is all guesswork you're doing. You're saying because they didn't recommend my case for promotion, it must be that there was some adverse CCR which is not communicated. So see, you made that presumption earlier, and that 80-81 was kept out because admittedly you did have negative.
I bow down, my lord. I bow down, my lord. With the lordship, my lord, my only, why I was not given promotion. Because of some entries with my CCR.
You don't know. That's the whole point. This is the same. You're making the same presumption, sir.
So that is why
maybe there's an overall assessment that the DPC makes.
The tribunal came to a conclusion that the DPC didn't found the records, didn't find me suitable. No reason. That is my humble grievance before my lord.
Now we heard you enough. Now,
okay,
the present petition is directed against the order dated. November 2011, passed by the Orissa Administrative Tribunal, Bhubaneswar, bracket 280, dismissing the petitioner's OA number 796 of 2010. Whereby his question, the DPC proceedings, review DPC proceedings held on 15th April 2010, and the consequential office order dated 22nd April 2010, whereby his prayer that he should be granted promotion from the post of forest ranger to OFS 2 on the date that his juniors got so promoted, was rejected. Paragraph, this is the second round of litigation on this issue brought forth by the petitioner. So, in the first round, the petitioner was able to make out a case that in view of non-communication of the adverse entry in his confidential character roles, bracket CCRs, for the year 1980-81, which were not communicated to him, the DPC could not have rejected his prayer, could not have taken into account such adverse CCRs while denying him promotion. Accepting this plea, the OAT had, by its order dated 22nd April 2010, directed that not 26th April, sorry, by its order dated, what was the earlier order, sir? 11th September 2009, in OA number 653 of 1996. Directed that the review DPC should be held excluding the CCR for 1980-81, which contained the adverse entry. Pursuant to the above order, the DPC met on 15th April 2010 to consider the case of the petitioner for promotion to the rank of ACF class 2, bracket now OFS group A, JV, bracket, but found the petitioner not suitable for such promotion. This was communicated to the petitioner by the impugned order dated, office order dated 22nd April 2010, which has been challenged in the present petition. Paragraph, learned counsel for the petitioner states that in an application filed under the Right to Information Act, he obtained the information that he obtained information on May 2011 from the office of the Principal Chief Conservator of Forests that information pertaining to the year 1981-82, 82-83, and 84-85 is not available to his office. Unquote. Paragraph. This, however, doesn't mean that the above statement pertained to adverse entries, since the question that was asked was open quotation, whether the adverse remarks in the CCR of Manoranjan Patnaik between the years 1981-82 to 84-85 were communicated to him as per rules or not. Unquote. It is likely that there were no adverse entries during the above years, which has prompted the reply, as noted here and before. Paragraph. It is not open to the, on the contrary, a perusal of the impugned order of the OAT reveals that the OAT called for the records and perused them. This is evident from the following sentences in para 6 of the impugned order, open quotation. The respondents have submitted copies of the proceedings of the review DPC held on 15 April 2010. We have perused the same. We find that the DPC, after consideration of the CCRs for the period from 1981-82 to 1984-85, found the appellant not suitable for promotion to the rank of ACF in OFS 2. Full stop, unquote. There's nothing in the above statements that enables the court to infer that the OAT did not examine the records, including the CCRs for the aforementioned years, or that the CCRs were not available at all. Paragraph. The OAT has come to the conclusion, and in the view of this court, rightly, that if the review DPC met on 15th April 2010, found the petitioner not suitable after considering all the CCRs, excluding the CCR for 8081, then that decision cannot be questioned by the OAT. Full stop. Paragraph. The settled legal position is that an employee has a right to be considered for promotion, but there's no inherent right to promotion as such. Stop. In the present case, the petitioner's case was indeed considered for promotion, but he was not found suitable. Full stop. There is no presumption that his unsuitability was on account of any adverse entries in the CCRs for the years other than 1980-81. Full stop. The suitability for promotion is based on an overall assessment, and it's not possible for the court to sit and appeal over such assessment. Paragraph. The court accordingly finds no merit in the present petition. It is dismissed as such.
Deeply obliged, ma'am.
All right.
Special weekly list item number 43.
None appears to not.
Special weekly list item number 47. 44, 45. Item 47.
47, 48, 49, no instruction, ma'am.
No instructions.
Special weekly list item number 50.
May please your lordship. This is a PIL matter, my lord. Matter relates to disposal of biomedical waste generated in government hospital, especially in SB Medical College and Hospital, Cuttack, my lord.
Right.
those biomedical waste are required to be disposed of in accordance with the provision contained in the Biomedical Waste Management and Handling Rules 1998, my lord. Prior to, my lord, 22nd February 2008, there was no facilities available for disposal of the biomedical waste in the SB Medical College and Hospital. When it came to the knowledge of the petitioner society not only approached the medical administration, but also has approached the district administration and to requested them to interfere in the matter and take necessary steps for installation of insulator. Insulator is the instrument where the biomedical waste can be disposed of. That is a statutory mandate, my lord. Then the petitioner society was constrained to file a writ application before this honorable court in shape of public interest litigation. This writ application, my lord. Then this honorable court interfere and intervene in the matter and pass an order on 3rd March, my lord. I may be permitted to draw your lord's kind attention to 3rd March 2008, my lord. On the said date, this honorable court has passed an order, and accordingly, the insulator was installed in the said hospital, my lord, in the year 2008. Thereafter, the petitioner came across a news item published in Delhi Odia newspaper, Dharitiri, wherein it has been reported that the insulator which has been installed in the year 2008 was not functional, my lord. Then we filed a miscase before this honorable court, which is being numbered as, which is also pending, my lord, which is being numbered as miscase number my lord, 15643 of 2014, my lord. And this miscase was heard by this honorable court twice. One on 19 September 2014, and thereafter on 20th February 2015, my lord. I would like to place the last order, that is 20th February 2015, my lord. May I place, my lord? The said order, my lord?
Yes, please.
That has been passed sometime in 20th February 2015, my lord. On the said date, my lord, after hearing both the parties, this honorable court has directed the secretary to Government of Orissa in Health and Family Welfare Department to file an affidavit indicating what immediate steps are being taken by the state to mitigate such situations. This order has not yet been complied. For that reason, this matter appears. My lord, this matter appears.
So there is no order after that?
My lord, no order, nor the secretary has complied to this order.
No. So for 7 years, no order. I mean, nothing has happened in the last 7 years.
Nothing has been happened, but the issue survived.
We'll ask them to file an affidavit now.
I would like to, my lord, to place the issue survived only because I would like to place the letter which has been issued by the Superintendent SB Medical College to the RDC, my lord. This is 14 years, the insulator is not functioning properly, my lord. For that reasons, I wouldn't. This is a letter issued by my lord Superintendent SB Medical College to the RDC, my lord. 12 January.
Repair.
My lord?
Urgent repair. They're saying there's a need for urgent repairs.
My lord. For urgent repair, they require 20 lakhs. If they will purchase 14 years have not been passed, my lord. This was installed in the year 2008. Now 2020,
All right, sir.
21.
All right, just listen to the order, sir.
My lord.
This is a PIL concerning disposal of biomedical waste.
My lord.
It has been pending since 2003 and several orders have been passed by the court in the matter. Full stop. The previous hearing took place more than 7 years ago on 20th February 2015 when the following order was passed. Reproduce the whole order. Learned counsel, the petitioner states that the above order has still not been complied with, inasmuch as the affidavit of the state has not been forthcoming. Paragraph. In order to demonstrate that the issue is very much alive, he has produced before the court copy of a letter dated 12th January 2021, addressed by the Superintendent SCB Medical College and Hospital, Cuttack, to the Secretary to the Revenue Divisional Commissioner, bracket CD, Cuttack, stating how an estimate for a sum of rupees 20 lakhs for repairing the incinerator had been sent to the Director of Medical Education and Training. And despite repeated letters, it had not yet been responded to. The letter points out how no, full stop. It is plain from the above letter that one of the major hospitals in Cuttack is still facing difficulties disposing of biomedical waste on account of a broken down incinerator. So this is indeed a serious matter which requires immediate attention. The Principal Chief Secretary Health is directed to immediately examine the issue and ensure that, if not already done, the incinerator at the SCB Medical College and Hospital is got immediately repaired, and that the hospital is also supplied with a state-of-the-art modern incinerator. So this, however, should not be restricted only to the SCB Medical College and Hospital, but other government hospitals elsewhere in Orissa as well. An affidavit in this regard be filed by the Additional Chief Secretary Health not later than 13th May 2022. List for hearing on 18th May. A copy of this order be communicated forthwith to the Additional Chief Secretary Health for compliance.
My lord, it will be listed on 18th June.
18th May, sir.
18th May.
So the affidavit is to be filed by 30th April.
13th May, sir. 13 May.
Weekly list. Press admission item number 1.
May I proceed? My lord, the petitioners, my lord, have questioned the virus of the rules, my lord. So that is the rule 10 and 12 to 13 of Orissa Subordinates Cooperative Service Recruitment and Conditional Service Rules 1992, read my lord, Amendment Rule 2011, my lord. Then my lord, the petitioners are the direct recruitees as they are, my lord, working as.
No reply has been filed. Notice has not gone.
My lord.
All right. It's a notice.
These persons have been recruited in the year 2019. They are challenging 2012 rule, and they are no way affected by this rule.
Pursuant to advertisement 2015, my lord, have been appointed in the year 2019, my lord.
Now, how are you affected by the rule?
The recruitment process has been conducted in accordance with this rule.
So how are you affected, sir, by these rules?
My lord, we are affected to suppose the promotional, that is the, my lord, that is, my lord, kindly see, my lord, annexure 3, my lord. That is the notification, 15 January 2012, my lord. There, my lord, page 30, lordship C. Page 29, my lord, rule 7, my lord, the petitions they are governed. And page 30, my lord, clause 8, my lord, the rule, my lord, page 30, my lord. In the said rule, rule 10 shall be substituted by the following rules, namely all group C employees, when we are the group C employees, serving in the cooperation department, officers of the registrar and divisional and circle officers and the cooperative institutions are eligible for appointment to the post of inspector of cooperative societies by way of selection, provided that he has completed not less than 5 years service, my lord. This rule, my lord, that is a bottleneck, we are affected by those.
How? You got appointed in 2019. So in 2024, your turn will come.
2019 directly to the post of inspector. And this rule which is placing, that is applicable to the promotions given to the post of inspectors.
Oh, so he's not affected at all.
No.
How are you affected, sir? You're not affected at all.
There, my lord, the page 31, lordship would see for a moment that clause 11 that says, my lord, for sub-rule B, my lord, the following sub-rules shall be substituted, namely, persons appointed to the post of inspector of cooperative societies by selection shall rank inter se in the order in which their names appear in the list prepared under Rule 11 and shall en bloc be senior, irrespective of the date of appointment to the persons appointed to the said grade by direct recruitment in the particular year.
If you are promoted, sir, by selection,
yes,
you will get senior to the direct recruits. So how is it affecting you? You're not telling us.
Promotion to the post of inspector. He is already a direct recruit to the post of inspector.
You have to tell us how you're affected. You see, the 3 petitioners who are directly appointed as inspectors of cooperative societies are challenging certain amendments to the Orissa Subordinate Cooperative Service Recruitment and Conditions of Service Rules 1992, brought about by a notification dated 5th January 2012. The petitioners have been unable to point out how the amendments which they are challenging actually affect them. Stop. In that view of the matter, none of the prayers.
Maybe only next week, Lord.
No, none of the prayers in the present petition can be considered. The petition is dismissed.
On my observe that we are not affected, but that may be observed.
You have to point out how you are affected. You have not pointed out. Yes.
Weekly list item number 2.
In this matter, notice has not been issued. My lord, I'm intending to file an amendment application. Here, a virus has been challenged. Another rule has been inadvertently missed out in the draft.
All right. Council, the petitioners seeks to file an amendment application. List on 7 July.
Weekly list item number 3.
May I please? This is a matter relating to the notification 148 issued by the Joint Commission.
No, ma'am. Let it be adjourned to 11/7. I'll file counter. But not 4 years, 6 years. The 2 cases are there. 7670.
Joint Commissioner, he says previous sanction of Joint Commissioner.
7670 Joint Commissioner. But 7673 is not.
So 7670, you say the impugn notice under section 148 of the Income Tax Act has been issued the sanction of the joint CIT and not the CIT. On this short ground and following the judgment of this court in Ambika and Steels.
On the current that is annexure 1.
Annexure. The impure notice is quashed. 7673.
And in this case, my lord, what happens, my lord? The jurisdictional officer who has the jurisdiction for making assessment, he has not issued notice on 50. It has been issued by some other officers. Jurisdiction lying with some other officers.
So will I issue notice?
No.
Yeah.
Notice,
No
he accepts notice till the next date, no coercive steps. List on 11 July.
Yeah.
Reply within 4 weeks. Adjourned of the
Weekly list item number 4.
May please, my lord, with your lordship's leave, may I submit, my lord?
Yes, Mr. Monty. Yes.
My lord, the company was declared insolvent and was insolvency proceeding was initiated, my lord, under the Insolvency and Bankruptcy Code, my lord.
Right.
The resolution professional was appointed.
Right.
Resolution plan was approved by the competent authority, challenged in the appellate forum, and appellate forum sustained it.
Yes.
Now the new management has come in, my lord. My lord, page 22. Now, my lord, for an earlier period, they are demanding royalty in respect of the earth, which was utilized, said to have been utilized by the company from their own premises. My lord.
Yes.
Page 22, I have quoted that resolution plan regarding outstanding government dues, my lord. 1/6, my lord. That is, accordingly, all claims of demands made by or liabilities or obligation owed or payable to, whether assessed or not, by the central government, the state government, any regulatory or local authority or body or any agency or instrumentality thereof, in relation to any dues, direct or indirect taxes, whether assessed or not, duties including stamp duties, electricity duties, water resources department related dues, enterprise social commitment fund, in relation to environment, penalties, fees, interest, fines, levies, cesses, and royalties. Royalties are specifically included in this plan, my lord. But this matter seems to have been covered by your lordship's earlier decision, 2 decisions, my lord, Facker and Sri Metallics, following the Ghanshyam Mishra case, my lord, by the Honorable Apex Court.
All right.
Annexure 1 is the demand notice. My lord.
All right. Notice, Mr. Mudali accepts notice on behalf of opposite parties. Reply we filed within 4 weeks. Adjourned of the next date till the next date. No coercive steps shall be taken against the petitioner pursuant to the impugned demand notice dated 11th March 2022.
But the item number 5 is not same management. But in relation to the water tax, but the demand notice is annexure 3, my lord.
No coercive steps should be taken pursuant to the demand notice at annexure 3.
I have got a separate prayer in this case, or an additional prayer in this case, my lord. Your lordship may kindly have a glance at page 60, my lord.
So we have stayed it.
My lord?
We have stayed it.
The page 60 is their proposed agreement they have given, my lord. So for they are asking me to deposit, shall deposit rupees 2,005 crores for water conservation fund. Earlier, this matter was before your lordships, and the government submitted there. It is neither a tax nor a fees. My lord, pays.
We have stayed the demand, sir.
My lord? All right. My demand is towards previous dues.
Subject to payment of the current dues.
That is, current dues, they are asking 2.5 crores for water conservation fund in order to erect garage. Current dues I will pay for the water I consume, Lord. That right. There cannot be any dispute.
So we are staying the further coercive steps pursuant to annexure 3.
Lord.
All right. List on 12th July.
12th July.
Weekly list for orders, item number 6.
Hearing will. I have prepared a small short note so that this is a suit filed by the plaintiff in the year 1973 in the court of Sub-Judge Baripada against the defendants for eviction and for a delivery of possession. The plaintiff was the ex-ruler of Mayurbhanj state. That is, after merger, the plaintiff claimed that he got some properties and that was used for private, privately by him exclusively, and the defendants have no right over the property to do puja and all. The defendants, the plaintiff has averred in the plaint that these defendants, they created trouble when the plaintiff sold away one portion of the land and also agreed to sell some of another portion of the land to outsiders. Then thereafter 144 proceeding was there. Then thereafter it was 145. Then thereafter properties were attached, and for which the cause of action arose and the plaintiff filed the suit against these defendants. The defendants, they filed that he has also given, described all those defendants, how they are related. Then defendants, they have claimed that they are the Raj Purohits and they were doing puja in that specific property, that Lades Durga was being worshipped there. That is, clay model of Devi Durga was worshipped, and the plaintiff has also admitted that up to 1968, when the king died, the clay model of Devi Durga was being worshipped there in that property, and thereafter also the son of ex-ruler, he also worshipped. The puja was also continued up to 69. Thereafter, no puja was being held, and thereafter he has admitted that that property is adjacent to the plaintiff's property. That is, another private Kichakasari was there. Kichakasari temple is there. That is the private deity of the ex-ruler, and this property is adjacent to that building, not inside the campus. And thereafter, several the defendants filed their written statements. Then thereafter, the this Devi Durga was not made a party by the plaintiff. Then Order 1 Rule 10 petition was filed. Then that was rejected by the trial court, which was allowed by this Honorable High Court. Then the present appellant Devi Durga was impleaded as a party. But order number 149, your lordship may see that some irregularities are there. After the defendant number 5 being made a party, it filed its written statement, but that was rejected by the trial court by its order dated, that is order number 149. Then that was rejected. Then this defendant number 3 was alleged that
he was all those family members were the Rajpurohits, and he was exclusively in possession over the property, and he was doing puja every year in that land. And their admitted fact is also there that there is a shed over that property. That is, in the earlier record of rights, it is mentioned at Devi Mela. From the evidences also it is found. I shall bring to your honor's notice also that was admittedly recorded as Devi Mela. Then 8 issues were framed. That main issue is, that is issue number 7, but the Law and Trial Court mixed up those 3 issues. That is, and he has, but although he has framed the issues, that is the public property or private property, but and after the intervention of this Honorable High Court, that DT was made a party, but he has failed to give a finding with regard to the fact that whether it is the main issue which is to be decided, that is public DT or private DT. There is no finding with regard to that by the trial court. Then the defendant number 3 has categorically mentioned in the written statement that he was doing the clay model puja, Devi Durga's puja, and by contribution of, earlier it was because Moirabhanj was the Moirabhanj state exchequer, the money was being paid, and thereafter after merger government was also paying some money, and also by the contribution of the public the puja is being made, and all the public were access, and they were doing Durga Puja there. As that is clay model, your honor will see that during this Durga Puja for 10 days, the puja used to go on. And that puja, that is yearly twice that puja is being observed. And it is admitted that king was doing that. And as your lordship knows, king, that state was there. That is, all the public were taking part on it. But after this merger, some of the properties by mistake that was handed over to the king, and that was claimed by them. This that one government officer was deputed, that some Matthew, but that notification original has not been produced. That which land, that just like aerodrome field was also given to the king, but some of the properties, those were being used by the public, their easementary right was there, although it was claimed by the king, my lord. Some of the properties, that is, in the nature of the properties is such that people used to have access to that property, and this is admittedly outside the palace, and just outside the boundary wall of the king. And thereafter, then may I take your lordships to the admission in the plaint. Then I shall take your lordships to the evidences, how they have admitted about the puja of that Devi Durga.
Madam,
also,
you are in a second appeal virtually, correct?
No, my lord. This is
first appeal. This is an appeal against the order of the single judge.
Yes.
The single judge's order is in which matter?
First appeal.
So virtually this is like a second appeal. Where is
yes,
the order?
yes, it's just like second appeal, but
Sir,
law is that here.
We know we are always wrong and you are always right, but sometimes we could be right.
Yes.
All right. Just show me the paper book. So in a second appeal, what are you supposed to do?
in second appeal, yes, substantial question of law, if your lordships ask me, my lord, that is point
What
of law.
is the substantial question of law?
Yes, my lord. So in my submission, I have given all those proposition of law, my lord. That is first thing, my lord. That although the property, so many irregularities are there, that the case has been decided as if the ex-ruler is present and he is a mere public, so that the case has been decided in one-sidedly by committing so many illegalities, my lord. That is, although as per the High Court direction, as I pointed out, my lord, 149 order number your lordship may peruse. I asked that the defendant number 5 was added as a party, that necessary party, but his written statement was rejected. First case. Then secondly, my lord, order number 160, may I take your lordship? Order number 160, one of the vital document, that is exhibit A, has been marked on exhibit, which will show that money was given to this dependent number 3 for the puja from the government. But there, although that has been marked as exhibit A, but the decisions, judgments by both the courts, my lord, they have kept silent. If that small document would have been taken into consideration, that which goes to the root of the case, then the decision would have been different. And not taking into consideration the admissible evidences, and also it vitiates the proceeding, as your lordship knows that it is in second appeal also, that forms a proposition of law. Order number 160, may I take your lordships to order number 160? Yes. That exhibit A has been marked.
Yes.
Which shows that this amount ₹10 was given to this petitioner for puja by the government.
Yes.
That is the document of 1929.
Right.
And from the evidences, I shall bring to your notice that they were doing puja and they were the purohits. From the mouth of the plaintiffs, evidences I shall bring to your notice that they were acting as Raj Purohits. What is their duty at the time of time of taking that to declare the king, that they have to be declared as king in front of the public, and these purohits, they used to do turban ceremony. They used to do that. Then now may I take your lordships to, these are the propositions of law. Then I shall bring to your
Yes, madam.
Another point, vital point, that is, admittedly, in this case, neither the plaintiff personally nor the power of attorney holder, they have been examined in this case.
Yes.
And proposition of law is that where a party to the suit does not appear in the witness box and states his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. Admittedly, these are the facts I am arguing, my lord. These are admitted facts. He has never been examined, nor the power of attorney holder who has filed the case, he has been, nor he has been examined in the case. Then order number 149, your lordship saw that, that is defendant number 5, WS rejected. And another vital point is also, my lord, that when there is a public question of public duty and private duty comes, then civil court has no jurisdiction. For that reason, the case has been decided in a hurried manner and without taking into consideration all those documents filed, exhibited by this defendant number 3. Now, shall I take your lordships to the admission of the plaint?
Yes.
Plaint, my lord. In my note I have given, your lordship may also look to that. That is plaint, paragraph 2. Iron shade roof wherein the late Maharaja was performing his private Durga Puja till his death in the year 1968 and 69. The plaintiff also performed Durga Puja there, but thereafter he discontinued the same and he confined his entire puja function before his family deity Ma Kichakasari, which temple adjoins the land described in Schedule A. The rest portion of the Schedule A land was a piece of vacant land and the entire land was in possession of the plaintiff, who was the absolute owner of the possession. Then, here the question he raised, that is a private deity. When categorically the defendants in its written statement has stated that it is the deity is a public deity, as for Goddess Durga was being worshipped by collecting donations from the public. As such, it can only be adjudicated under Orissa Hindu Religious Endowment Act 1951 under section 41. And the suit before the civil court is not maintainable, being the jurisdiction excluded under section 73 of the Orissa Hindu Religious Endowment Act 1951. Then may I take your lordships to the admissions, that is some of the PW1 witness for the plaintiff, para 13, PW1. Para 13, as your lordships got it, that is the original letter of Mr. Raja was lost. The name of the suit properties is mentioned as Devi Mela in Exhibit 1. He has admitted. The name of the suit properties is mentioned as Devi Mela in Exhibit 1. I have not worked together with Mr. V.S. Matthew at any time. Some other properties of plaintiff are also in dispute in the suit property. Then so and so. Then, para 14. I cannot tell the reason why the plaintiff stopped Durga Puja on the suit land from the year 1969 ago. Puja were being done regularly, Goddess Kuchakasari, as well as on the suit land by Maharaja. But since 1969, Puja on the suit land has been discontinued. An admitted fact is, my lord, that 68, the ruler, the Maharaja died. And the case of the plaintiff that 68, he did the puja, 69 also puja was going on thereafter. The case has been set up like that to deprive these defendants. Then Devi Mela, including the shed, is on an area of about 9 hunts. In Devi Mela, that is the plaintiff's, it comprises of 2 plots. The site of the northeastern portion of the suit land has been sold to so-and-so, it sold so-and-so, the plaintiff sold the land to his legal representation, Vijay Kumar Patnaik, that is the power of attorney. Then para 17. That is cross-examination. Cross-examination. I cannot say if V.S. Matthew is alive or not. I cannot tell in which year the Devi Mela was constructed, but I know fully well that it was done by Maharaja Purnachandra Bhansdev. It was constructed for the purpose of worshipping Durga Devi deity. I cannot say who got this Devi Mela constructed. I cannot say if late Loknath Praharaj got it constructed. Then 18. There was no Durga Puja in the Devi Mela after the year 69. As out Puja has been stopped. I do not go to that side during Durga Puja and all. Then PW2, para 2. During the state regime, clay image of goddess Durga was being worshipped. In autumn, show as on in the shade situates on the Devi Mala. That image was being immersed after puja ceremony was over. At no other time, any clay image or idol of Durga Devi was being worshipped. Then, that para 2, next page, it starts. People were congregating on that space during Durga Puja. This continued even after the merger of the state till about 1969. There was puja in 1968 and 69, but after that it was stopped. And before and then, para 5. Para 2. There was puja in 68-69, but after that it was stopped. Before and after the merger till so Maharaja, no deity or idol of Goddess Durga installed in that Devi Mela. After merger for the daily worship, the shade was left unused thereby. After long back during the state regime, the boys of our Sahi was holding their class in that shade on Devi Mela. After reconstruction, most probably some that flood used to come at that time. That was used as school for some reason. After reconstruction of regular school building, the school was shifted from there. It is not a fact that Durga Devi was permanently installed in that set, and it was regularly worshipped by the people. We are not paying any subscription for the puja till the time of puja and all. Then, from this, it shows that it was used by the public and for public purpose, and admitted that goddess Durga was being worshipped there, whose image was being immersed also. Then cross-examination. The shade on the Devi Mela is a permanent structure. Structure constructed for the purpose of performing Durga Puja. This is very important, madam. And by the plaintiff, I cannot say exactly when the structure was constructed, but I have been seeing this since my childhood. There is a dais and a gate in that shed. The adjoining vacant space lies unused. Your lordship can imagine, well imagine, that where this yearly twice puja is being observed, there one image of that Goddess Durga is being kept, and every day there some dhoops and all these things. That is not worshipped in a bigger way, but every day some it is everywhere in Cuttack also all the Devi Mandaps, because it was asserted in the year 1929 that Devi Mela, that Mela used to be organized there and people used to come there, congregate there and enjoy that the Lades Durga Puja. Then it is the cross-examination, the plaintiff's witness. He has admitted that from his childhood, he is of year when he deposed, he is of year 58 years. And he has mentioned that from his childhood he is seeing. And that vital document Exhibit A, if it would have been taken into consideration, then it would have different, that judgment would have been different. Because that is the year, that was of the year 1929, when money was being paid to the family of these defendants. Rupees 10 was given at that time for this doing puja and all. Then, para 6, Dasara ceremony was observed by the Maharaja by installing clay image of goddess Durga in Devi Mela and worshipping it. Members of public used to go and offer bhoga to the deity during Dasara festival. That is the deposition of PW2. Then members of public used to go and offer bhoga to the deity during Dasara festival. The school functioned in shade for about 2-3 years. These took place more than 25 to 30 years back. Maharaja had appointed the father of defendant number 3 at times to do the puja work of Durga Devi. The plaintiff got the last puja of the deity done in 1969. Then,
my lord, may I be permitted to submit one thing, my lord? My lord.
And DWs also deposed in the deposed, and that is not challenged. In cross-examination also I shall point out to your lordships, DWs, that but without taking into consideration, in my short note I have mentioned, then to shortcut. Defendant number 3, shall I go through the depositions? I have seen the suit Devi Mela land. It is situated in front of my house. There is an open shed with tin roof and a dais. During Dasara month, clay image of goddess Durga is being worshipped there. On other days, the member of defendant number 3 family worship a jantra there. Yes, I could not explain that properly. That jantra used to be kept there. For throughout the year it is being worshipped, and at the time of Durga Puja only this function time that clay image of the Durga Devi is being worshipped. Then cross-examination. During the state regime, state was giving some aid for the performance of puja to the defendant number 3. The in shape of kinds. The Maharaja was giving this aid to the father of the defendant number 3 in shape of kinds and other expenses in shape of money to clay image. Then, thereafter, defendant number 3, Tulsi Praharaj, started doing the puja by taking subscription from us. We had installed some images of goddess Durga and worshipping the same. I cannot say from where defendant number 3 brought this image and where he installed it. Not a fact that daily worship of deity was not being done in the suit land. Then, Then different number 3. 3 is, that is, I am dependent number 3 in the suit. I have filed written statement. The suit property is Devi Mela, which comprises of a shed with connected pandal and open space. It is not a shed but a house. This is situated outside the premises of the palace Kichakasari. Inside the palace compound, it is Kichakasari temple is inside the palace compound. It is the personal deity of Maharaja with regard to Kichakasari. But this Durga Devi, that land is outside the king's palace. Then the ex-state government of Mayurbhanj had constructed the house for purpose of holding Durga Puja by the member of the public. In autumn months, clay image of goddess Durga was being worshipped in that house, and in ordinary time, Jantra of goddess Durga was being worshipped. Those worships are being done since time immemorial. The clay image was being done and puja performed at the expense of the state government. After merger, state government was paying money. That contribution collected by the members of the public and members of my family. The Jantra Puja was being done by my forefathers, and it is being done by my since my childhood. All these depositions are given by more than 45, 50 or 60 years old, and they are categorically evidence that from their childhood they know that puja was going on. Then para 3, there is mention about this exhibit A. That is para 4. There was a family petition in our family, and the duty of performing Durga Puja was allotted to the share of my father. My forefathers were appointed as representatives of the state government to represent the state in all pujas for performance of the puja. The present government has been giving grants of ₹10. Exhibit A is the copy of order of the Tahsildar to that effect. We are getting this grant till today. That is very, very important, my lord. Tahsildar was giving, after this merger, Tahsildar was giving ₹10 to the, for this puja purpose, to the family of the Durga Devi. Not family of the Sevaka of Durga Devi. That is a different number 3. Because it is a claim of the dependents are there. They are the hereditary pujakas of the Sevas of that Durga Devi deity. Then Exhibit 6 is not in my signature. Radha Krishna Bhanjak came and demanded to shift the Durga Jantra from the said. That is, there he has mentioned that is after this agreement to sell and all, when they wanted to remove this Jantra and all, then dispute arose and 145 proceedings started. Then the cause of action arose and the king filed the suit. The son of the king, ex-ruler, filed the suit. Then in the cross-examination, that state used to pay money for the puja through treasury till 1929, which I have heard from my father. This was being paid by the state for construction of clay image of goddess Durga. After 1982, this money was given by the Maharaja. I have no accounts now to produce before the court regarding this help or its expenses. My family used to pay ₹28. That ₹10, that is Exhibit A. If that document is there, my lord, it will go to the root of the case. That is the receipt given by that is the ROR where the receipt given by the Tahsildar. That is ₹10 is being given to the defendants. Then para 9, it is mentioned that the shade on it with cemented dais also belong to the state government. There was green fencing around the Devi Mela, but the fence has since been damaged. I do not say that it is a shed. I say that it is a house. That is a tin roofed house. It has been admitted by some of the plaintiff's witnesses also. Then paragraph 13. Nitai Praharaj is my elder brother who resides separately. I am an employee of the cooperative society last 21 years and has been posted at Karanjia. I was posted at Baripada for last 4 years. The last of the period I was outside Baripada, it is not a fact that Delhi worship is not being done in Devi Mela. I say that Delhi Puja was being performed because it is Vijayasthali of the Jantra. Then this Nitai Praharaj, my lord, there is mention that admittedly he is the elder brother of the defendant number 3. That will corroborate with the defendant number, that is defendant number 3, page 24. Nitai is the elder brother of 3. That is corroborated by another. Then first I finish up here, my lord. Then para 14. That is because of a school was being held in Devi Mela about 15 years back. So the Jantra was taken over to the house. Because admittedly the house of this Sevayat was just in front of the land, disputed property. So that because of the school was going on, he has mentioned that it was kept there. But puja was going on as usual. It is not a fact that I have kept some images there to create trouble. Then plaintiff's witness, that is
Madam, you have put all these points in your note. All right.
Yes, my lord.
What do you want
Only
to say?
with regard.
My lord, I would like to submit. My lord, I am on behalf of Mr. D. Nanda, and we have engaged Mr. The counsel, Mr. UC Patnaik. My lord, I am here to only submit. My lord, the present rate of appeal is not maintainable, my lord. As per the bar under section 100A, the provision is that no further appeal in certain cases, notwithstanding anything contained in any letter patent for any high court or in any instrument having the force of law or in other law for the time being in force, where any appeal from an original rapid decree or order is heard and decided by a single judge of a high court, no further appeal shall lie from
Is
the
it
judgment.
prospective or retrospective?
Hello?
When was this provision introduced?
This provision was introduced in the year 2002.
And when was this appeal filed?
This appeal was filed in the year 1997.
All right. Anything else you want to say?
My lord, there are 2 judgments of this honorable court, my lord. Where the present issue that has been raised by this honorable court has been dealt with. I would like to draw your lordship's attention the judgment of Union of India versus Steel Authority of India. That is an AHO of 1996.
Union of India versus Steel Authority.
My lord.
There it said further appeal is not maintainable.
My lord.
All right. We'll examine it. Then there are so many HOs here. All right.
Another point with regard to this aspect, madam, this AHO is here both fact and law can be gone into. I have given 2 decisions of the Honorable Appellate Court decisions as well as of our own High Court that it is, and I have not seen that decision, but it is not a second appeal, and a writ appeal also. It is not a writ appeal; it is a regular appeal from the first appeal. This AHO is.
This is AHO.
Yes, madam. Appeal against High Court order. It is a.
This decision which is given. Have you given her a copy?
Writ appeal.
My lord, I'll supply the copy, madam.
And it has been added.
Look at what let's say.
Yes.
Union of India versus Steel Authority. What is it?
Union of India versus Steel Authority.
What is it? What is it? Is it? It is an AHO.
MA.
AHO.
On merits, do you have anything to say? You file your respective notes of arguments. All right.
I'll let supply the notes of submission.
Only these two judgments is supplied to me. I shall give.
Both
Now
parties
it's
are
not
permitted
applicable
to
this.
supply their respective notes of
Yes.
arguments within 1 week. Orders reserved. All right, madam.
Well, these two irregularities I have not mentioned in my short note. That is order
No, you
number
can file some more
149
notes,
and
madam.
160.
Whatever notes you want, you file.
Yes.
All right.
Weekly list item number 7.
Well, my lord, probably there is a typographical error.
The only correction of the order.
Yeah, order is corrected as prayed for. All right.
Obligement.
Weekly list item 8.
None appears dismissal on prosecution.
Weekly list item number 9.
None appears dismissal numbers.
Weekly list item number 10.
Item 10, my lords, I may kindly permitted to withdraw.
Kindly, yeah.
Weekly
Dismiss
list,
is withdrawn, yeah.
weekly list item 11.
None appears dismissal numbers.
Weekly list item number 12.
Lordship.
Have not solved the copy.
But here, the petitioner has filed this application challenging the illegal construction of mandir over a school building.
Encroachers, where are the encroachers, sir?
Yes, encroached. The school building has been encroached by the some antisocial person. I have made them party also. That the school building, the Lordship Annexure 4, Lordship page 23, Lord.
But this Annexure 3 is your representation.
Yes, my representation collector, Lordship directly collector.
No. Where is the proof of delivery of this representation?
But yes, but the Lordship, I have made party to all the persons also.
No. Where is the proof of delivery of the representation?
Oh, yes, proof, Lordship, the page 15, Lord. Page 15, this is the Goita Sakhir, Lord. Page 15, Lord. Already received, Lord. That's the ODI, Lord. Page 15. That receipt is there.
It is there. All right.
Lord, that letter was sent on 26th of November 2018.
Yes, Lord.
18. That letter which my learned senior is placing now, it was sent on 26th of November 2018.
18.
Yes.
You're waiting for 3 years to file the writ petition, sir.
Then Lordship Annexure 3, Lord. Annexure 3.
The construction must have been completed.
Annexure 3 also there.
What year is that? Annexure 3?
Annexure 3, 21. I have also to 1921 also I have given them in
March 2020.
Yes, but that is.
There's no proof of that, sir.
Yes.
But the fact remains, Lord, the school building is that is enclosed by the authority, Lord, by the persons, Lord. Lordship, direct collector make an inquiry that physically.
Even you're not naming the encroachers, sir, in your representation.
I have given the names, Lord.
No, in the representation.
Yes, representations they have not named, but I have made the party.
You have to name them the representation.
I made
You make a fresh representation. The petitioners are permitted to make a fresh representation.
Yes.
To the authorities, naming the encroachers.
Yes.
And after following up on such a representation to make to
The
seek
collector
appropriate
will-
remedies in accordance with law.
The collector make an
Disposed of
inquiry.
the above terms. Yes.
The collector make an inquiry, giving the opportunity hearing to the petitioner.
No, not yet. You first make a representation.
Weekly list item 13.
That will be disposed within the short period.
Your Lordship. May it please the Lordship. Your Lordship's order dated 2/2/2022. Modification is in the paragraph 6. The court directs that the amount collected from the petitioner's as application fees be refunded to him within a period of 8 weeks from today. It will be application fees along with the consideration amount what we have deposited.
Along with the
License fee, the consideration fee. Because we were the successful owner in the lottery, but by virtue of the court's order, the cancel was the e-auction was cancelled. So the court has a directed to refund the entire amount to the business.
all right. The modification is allowed as prayed for. The order shall read as under. You include the word consideration fee.
License fee, madam.
License fee. All right.
Weekly list item 14. Item number 14.
Item number 14.
So many defects, sir. List after removal of defects.
Weekly list item 15.
Item 15, my lord. I have defect number 6. I have given the copy. That is the proof, my lord.
All right. What is the matter about?
My lord, I have given your lordship. This is a. I have challenged the impugned order annexure 7, my lord, page 31, and I have a squarely covered matter. I have given to judgment of your lordship. Fortunately, your lordship is the author of that judgment of Honorable Delhi High Court, and which was confirmed by the Honorable Apex Court, my lord. The petitioner was recruitment was started advertisement in 1999.
All right.
But due to
notice, all right, notice. Who's there for the Union of India? No.
No, my lord. I am there.
Okay.
My lord, to judgments I have given
notice for the opposite parties.
OP number 1 to 4. That is a covered matter.
Accountant General also is yours, no?
No, no. Principal accountant is not.
All right. Notice to opposite party number 5 by registered free post returnable by the next date. Replies be filed within 8 weeks of service of notice. Rejoinder before the next date.
May I pray, my lord, since it is a covered and it was upheld by the
let them examine it. You give them copies of these judgments.
My lord.
3rd August.
Deadline, please, my lord.
Weekly list item 16.
My lord, the matter relating to the running of a heavy vehicle truck of the opposite party number 10 on the Panchayat Road, my lord. The petitioner are approached this honorable court, and this honorable court pleased to direct the opposite party number 5 to consider the representation of the petitioner, and after taking report from the State Pollution Control Board, my lord. My lord, the State Control Board also, my lord, that is at annexer page at my lord, report of the State Pollution Control Board at page 91. Page, my lord, your lordship, kindly see, my lord. That is at page 86, my lord. Page 86, that the my lord, I draw your attention serial number 5, man. There is a very high density of the pollution and vibration on the road, man, Panchayat Road, man. But due to running of the heavy vehicle more than 40 tons and 18 wheels trucks, man, of the opposite party number 10, man.
But he has passed an order on 4th March.
That is annexer 14, page 94, man.
Page 97, come to 97.
Yes, man.
They have imposed several restrictions.
So what is wrong with this?
Wrong is the pollution control board also not recommended to running a vehicle of the density people density area, man.
I can't understand anything that's. Are you able to understand? I don't know.
That is at page malad, your lordship 87, malad. Recommendation. Alternate route to avoid the human habitation may be assessed and consider, or a separate road corridor avoiding human habitation may be constructed for the transportation of coal and fly ash, malad. That is at page 87, malad.
Actually, who made the recommendations?
Malad, recommendation by the State Pollution Control Board, annexer 11, page 84, malad.
Sir, this order has been passed only on 4th March. Has it worked? Not worked? You don't even want to give it a try. Some time to get worked out. Let it be tried out and see. Let us see if it controls the pollution. All these measures.
Measure is the recent that is on 2022. That is the report of the 2/2022 recent. pollution, my lord. A report of the pollution control board.
All right, you just say notice at this stage.
Your Lordship may kindly turn to page 95. That report of the pollution control has been taken note of.
I know, but he thinks this may not be enough to control the pollution. That's his
these restrictions.
Apprehension is that. Why don't you go to the NGT, sir?
My lord, this is a matter of the vibration, due to vibration, life and property of the people, my lord.
Everywhere, all matters of pollution are involving the life and property of people, sir.
It is not on pollution, my lord, vibration of the public. Your lordship, kindly also see the regional transport officer Talche, my lord, annexure 12, my lord. My lord, there is no provision in the MV Act, Motor Vehicle Act, for the running of the heavy vehicle in the Panchayat road, my lord. There's a report also at annexure 12, page 91, my lord.
No. What flying of heavy vehicles, they may not be provisions in the MV Act. This is neither here nor there. My question to you is, why are you not going to the NGT?
Well,
NGT can monitor these things far better, sir. Actual levels of pollution, they can ask for reports. You please go to the NGT. You see, you say this
is there is a damage of the house of the also people.
This is the second round of litigation at the instance of the villagers. In and around police station, NTPC. In district Anugul, complaining of pollution on account of the plying of trucks. We'll stop earlier. The petitioner's representation had been asked by this court to be considered by the Tahsildar Kaniha by an order dated what is the date of this court's order? 3rd November 2021. And the petition civil 32113 of 2021. Pursuant thereto, after hearing the petitioners, the Tahsildar has passed a detailed order on 4th March 2022, where he has recommended a series of measures. Paragraph, it appears that the petitioners are still not happy with the measures recommended. Full stop. Since the matter relates to pollution, control of pollution on account of flying of vehicles loaded with fly ash, the court is of the view that better and effective monitoring is possible on the intervention of the National Green Tribunal at its bench at Kolkata, which has jurisdiction over the area. Consequently, the petitioners are permitted to approach the NGT with an appropriate petition for release. The petition is disposed of.
Equal list item 17.
May I please? This is a petition. This is application by challenging say notice 148 minus, but issued after 30th June 2021. It has to
so
go
that is 7684, 768.
Equal list for admission item number 18.
May it please your Lordships. Lordship, on 26/4/2000, the question of law was framed. The question is whether in the facts and circumstances of the case, the tribunal was justified in holding that Section 5 within bracket 3 of the CST Act was not attracted. But the facts are one Indian export house entered into a contract with a foreign buyer. Pre-existing contract was there. Then Indian export house entered into another contract with one Tana export house. Then
I think we recently dealt with this matter, no?
Yes.
Recently, a similar matter we dealt with. Export house entering into a contract with an Indian agency.
I'll draw your lawsuit's kind attention to the tribunal's finding. That is, lawsuit will kindly see the tribunal's order. Tribunal has agreed, and tribunal has said that yes, lawsuit will kindly turn to internal page 3 of the tribunal's order, para 3.1. Now coming to the point with regard to the claim for deduction under section 5.3 of the CST Act, the position can be analyzed as follows. True, there was an export contract by a foreign buyer with the Indian export house for purchase of groundnuts. Messrs. Tana Exports Private Limited have entered into an agreement with the appellant dealer on 1386, 7386 and 8386 for purchase of groundnut seeds. This shows that the groundnuts were purchased by the exporter from KR Oil Industry, that is the petitioner. KR Oil Industry are not the exporters. KR Oil Industry, that is the appellant dealer, purchased the goods locally. The taxable event occurred in the hands of KR Oil Industry, who are not the exporters. Subsection 3 of section 5 of the CST Act, the last sale or purchase of any goods preceding the sale or purchase, occasioning the export of those goods out but of the territory of India shall be deemed to be in course of such export. If such last sale or purchase took place after and was for the purchase of complying with the agreement or order for or relation to such export. In the present case, the purchase made by the appellant dealer is not a purchase occasioning the export of the goods out of the territory of India. That is the section 5.3. There is a deeming clause. And when a deeming clause is there, it has to be taken to a logical end. And I will place that matter, section 5.3 of the CST Act. It was brought after the judgment of Sirajuddin's case in Supreme Court. Lordship will see the section, notwithstanding anything contained in subsection 1, the last sale or purchase of any goods preceding the sale or purchase occasioning the export of those goods out of the territory of India shall also be deemed to be in the course of such export. If such last sale or purchase
will not be amenable to sales tax.
Amenable to sales.
Not amenable.
Yes.
What is your contention?
And there is no dispute that I am selling it to Tana. Tana is giving it to Indian export house, who is ultimately giving it to the buyers, foreign buyers.
No, so that's two transactions, not one.
Yes.
No, you are giving it to Tana. Tana is giving it to the export house, which is exporting. So there are
that is malus because of the pre-existing contract, and the decisions are that in order to comply the pre-existing contract, if it is there.
You are KR Oil Industry, right?
Yeah, I am KR Oil Industry.
So you have.
I am purchasing groundnut. Indian export house.
So that becomes the second transaction.
Second transaction.
So then it's not 5.3 is not attracted, sir. That becomes the second transaction. So the question will be answered against you. While admitting this revision petition on 26th April 2000, the following question was framed for consideration. Reproduce the question. Paragraphs involved succinctly. In para 3.1, it is stated of the said order dated 2nd February 95. No, 5th January 95. It is stated as under reproduce para 3.1. Paragraph section 5 bracket 3 of the Central Sales Tax Act reads as under. It is plain that there are two transactions preceding the actual export. That is, the present appellant, the present SSC, KR Oil Industry, sells groundnuts to Dana exporters, who then sell it to Indian Export House, which then exports the consignment of groundnuts. Since this is not the transaction involving the petitioner is not the one immediately preceding the transaction that occasions the export. Section 5 bracket 3 of the CST Act is not attractive. The question is accordingly answered against the SSC in favor of the department. The revision is disposed of.
By flux of time, this petitioner has also disappeared. So there is no monetary gain on my part.
You are doing it for peanuts.
Yes. Correct, my lords. I was thinking whether I will place it or not. Then I said that all right, let me place it.
Weekly list item 19. Item number 19.
The ICMR matter, my lord.
Yes. No, who's for the petitioner?
The petitioner is Sangram Das.
All right, none appears. This was not possible. All right.
Weekly list item 20.
The item 20, my lords, may read the lordships.
Yeah.
Lordship will see there was an interim order by this honorable court. Well, this honorable court directed me to deposit 33.13%.
Correct. Of 2 crores 46
yes,
lakhs.
and I have deposited it. The tax amount is 2 crores something, my lords. Then, my lords, the
Orissa entry tax.
And the
now it's decided by the Constitutional Bench.
No, it's decided. And this is whether your lordship have placed this matter that import from outside the country.
Yes, madam. That has also been decided against the SSC.
No. My lords, that your lordship, whether it will be discrimination or not, I have to demonstrate.
And there the Honorable Supreme Court has remanded those particular matters have been admitted. So this is not a matter where
I have been in Supreme Court, my lords.
So that's a separate writ application then.
This petitioner, I am not there, my lords. I am not there, please. I am arguing in your favor. Don't worry. My lords, here, my lords, one of the issues is whether the coal I have purchased will be eligible for ITC or not. Now, your lordship's judgment, what I propose is like this. Let them take out the coal and balance amount, unless I'll file appeal. And since I have deposited 33.13%, so I need not file so far as the pre-deposit concerned, because 20% is pre-deposit. I have paid 33.13, so that is 10% more. I am liable to be refunded another 10% matters.
Lord, there are about 10 points on which this assessment order has been passed. Yes, on one point that notification has also been passed. So all these can be taken care of by the appellate authority, my lord.
Yes, that's what I am suggesting. Is better.
All right, counsel, the petitioner seeks leave to withdraw the present petition with liberty to assail the impugned assessment order passed under the Orissa Entry Tax Act 1999 by way of an appeal. If such a appeal is filed not later than 9th May 2022, accompanied by an application for condonation of delay. You say 1st May, sorry, 2nd May, accompanied by an application for condonation of delay, giving the reason for the delay on account of the pendency of the present petition, shall be considered on its merits by the appellate authority. As regards pre-deposit, since the petitioner has already complied with an interim order passed by this court on 14 July 2010, requiring it to deposit 33.1%
of the tax
demand with the department as a condition for stay. No further amount need be deposited by the petitioner by way of a pre-deposit for the purposes of the appeal.
Yes. Annexure 1 to be returned, my lord, with a substituted copy.
Yeah. Annexure 1 being the original assessment order be returned to the petitioner, subject to it being substituted by an attested photocopy thereof. The interim order passed with this court on 14 July 2010 will continue till such time the appellate authority passes an appropriate interim order on an application to be filed along with the appeal for the above purpose.
Obliged.
The petition is supposed. Right, sir.
I may be pardoned, my lord. Item 19, last occasion, I so wrongly SG Das senior counsel name is reflected as SG. That may be corrected in this time also name will be reflected.
All right, all right.
Weekly list item 21.
May I appeal, my lord? I may be permitted to supply the translation code, my lord. My lord, this is the matter of land acquisition matter, my lord. The opposite party number 2 not accepting our objection as because the ancestors are dead and the notice has been served on the dead persons. Therefore, we filed the objections in before the opposite party number 2, which was not accepted by the opposite party number. Therefore, this is the case.
So there's no interim order, nothing.
No, my lord.
No interim.
They have filed counter, my lord. In their counter, they are stated that.
Where's the question of now being permitted to participate is a 2007 case. Look at the prayer in your writ petition.
My lord. My lord, there is. It is therefore prayed that your lordship would be graciously pleased to issue writ of mandamus directing the opposite party number 2 to allow the petitioners to participate in the hearing of LA case number 4 of.
Is this case still pending? Is this case still pending?
At time of filing counter, this was pending. Because the counter was also filed in the year 2011. Lord.
Well, it is pending now.
But just may I point out only one thing, Lord. Now, what in our counter we have taken a stand that the present petitioners who are claiming that they should be entitled to get the land acquisition compensation, in our counter we have stated that their predecessors have already sold their share of land to a third party.
Oh.
So there, and in fact, the land rent receipts have also been enclosed in the counter affidavit to substantiate the stand that it has been already sold.
Oh.
Now in rejoinder, in the last month, in rejoinder, now the petitioner comes up with a story that the sale deed is invalid. The genuine
to go to the civil court for that.
Yes, that's why my humble submission is as per section 18 of.
Kindly peruse the document I have filed, my lord.
So all this can't be examined in writ petition,
Yes.
sir. You
No,
go
no,
to
my
the
lord.
civil court.
I'm not that point, my lord. This is not. I'm not disputing that. The person sell the property in the 1953 when the person is alive. Mongoli Malik is alive.
Whatever it is, sir, that can't be examined in the writ petition here.
In 1997, my lord, he has sold another property. His own. His name is Adikanda Malik, son of Banai Malik. This is the record I have shown, my lord.
All right. You say the challenge in the present petition. No, the prayer in the present petition is for a direction to the Special Land Acquisition Officer Jagat Singhpur to permit the petitioners to participate in LA case number 4 of 2007 arising out of the acquisition of lands in Mauza, Vijay Chandrapur at Paradeep for a major industrial project at Paradeep. Paragraph in reply to the petition, it is pointed out that the predecessors of the present petitioners have already sold the lands in question to third parties.
And in 1953.
And the registered sale deeds in respect thereof have been enclosed with the counter affidavit. Paragraph in rejoinder, it is sought to be pointed out by the petitioners that those sale deeds are not valid in the eye of law. In fact, even today, certain documents have been handed over for the same to the same effect. Paragraph, the only remedy available to the petitioners is to get the sale deeds declared invalid by a civil court by instituting appropriate proceedings for that purpose. Unless that is done, it is not possible to consider the prayers made by the petitioner. The writ petition is disposed of in the above terms.
List item 22.
I am simple prayer, my lord. Still then the sanction should be stopped, my lord. Otherwise, the opposite will take in the morning. For people's money, my lord.
Yes.
Item number 22.
May I plead your lordship? On the last occasion, I handed over a date chart to your lordship. Lordship, where is the date chart which I submitted on the last occasion?
Tell us what the matter is about, sir.
Regarding illegal detention, your lordship, the petitioner was apprehended in a case in the year 1999, your lordship. In 2003, he was convicted to undergo RI for life, your lordship. Thereafter, he preferred appeal before this court.
So counter has been filed saying what?
Yes,
what have you said, sir?
That will can come to page 20 of the affidavit. That the order of conviction and the sentence is modified. It is running page 20 of my affidavit. The person has been discharged. Then the person has been directed, after that order of conviction has been modified, directed to undergo RI for a period of 7 years and to pay a fine of rupees 10,000. In default, to undergo RI for a period of further 1 year. So the order has been passed on 4/8/2009. And because of non-payment of fine, you are there for some days in the jail, and subsequently, after the
you didn't pay the fine amount, sir.
Pardon, your lordship.
You did not pay the fine amount.
Yes, your lordship. That I didn't pay, your lordship. And by the time the judgment was passed, your lordship, I had already undergone 10 years, 5 months in the imprisonment, your lordship. And your lordship may peruse the earlier order passed by this court.
Even if the fine amount had not been paid, even that default sentence is covered, sir.
Yes, your lordship.
Mr. Katkia, even the default sentence is covered in the 10 years.
Plus, that is plus, of course, that has happened in this case, but 428, section 428 of CRPC speaks. That doesn't include the default payment of fine. But because 1 year has been elapsed in the meantime, because after 7 years he has already traveled 10 years of imprisonment.
No, if he has actually undergone far more sentence than even if you add the default sentence.
But he has not been kept behind the bar for many days, because after communication of the order, immediately the Lawrence Session Judge has passed another order directing the prison authorities to release him, and he has been released. It may
no, that is after the order passing this writ petition, sir.
The order
that is passed by order passed in this present petition. He's got released.
No,
the order is 20th April 2010. No. 20th April 2010.
Yes, your lordship.
It's only after the order passed in this writ petition that he was released.
Your lordship, page 24. That is dated this the 20th day of November 2009.
Correct, sir. He had not been released then.
Yes, by that he was not released.
He was not released, sir. He was released only because of the order passed in this writ petition.
Yes, I pray for a short adjournment for another clarification.
Counsel for the opposite parties needs some more time for clarification. Add his request list on 7th April, sir, not beyond that.
Weekly list item 24. Item number 24.
None appears dismissed for non-prosecution.
Weekly list item number 25.
Item 25, my lords, it's the
May-
food security petition, my lords.
May please, your lordship. My lord, last occasion, your lordship asked us whether the limited prayer was whether the state government is insisting on the Aadhaar linkage for the benefit, my lord. We have filed an affidavit, my lord, and I've served a copy on him also. Our affidavit is very specific, my lord. The state government is in no way insisting on linking of Aadhaar.
All right.
Your lordship, if your lordship will peruse the affidavit, there your lordship will see that, my lord, this figure that my learned brother is showing, this is a very dynamic figure, my lord. It keeps decreasing and increasing each day, my lord. So what the government has done is we have 378 ration card management centers have been set up. Anybody who wants can and just have access the center, registered his name after a short inquiry, my lord, and going through those exclusion and inclusion criteria, he will be given the benefit, my lord. As a lordship, no, there is.
Let's try this out. You see if it works.
My lords, this is something, my lords, that the state has been saying not in the latest affidavit. Previous affidavit, my lords, when
Yes,
this
we're doing that.
petition was filed also, my lords, this Aadhaar issue was one of the issues that was there.
No, we're not only on Aadhaar.
Yes, my lords.
She's on the other part.
Yes, my lords.
About increasing the number of the coverage.
That's right, my lords. My lords, in fact, my lords, that infrastructure is there. It's not that it has come up recently, my lords.
No, they are saying that they will put up an information portal. Just come to para 5.
Yes, sir.
They're volunteering to keep all of this in the public domain.
Para 5, my lords. Which affidavit?
No, my lord, latest affidavit has
My
3
lords, it
paragraphs.
has just
only,
3
my lord.
paragraphs. My lords.
No,
The
but that is
latest
also
one.
there. My lord, can I clarify, my lord, one thing? My lord, as your lordship know, there are 2 schemes.
That state scheme and the
And the central scheme and the state scheme, my lord. What is happening, my lord? Anybody who's found eligible is either included in the central scheme, and in the central scheme there is no if there is no vacancy, they're adjusted in the state scheme. Once there's a vacancy in the central government scheme, these people are upgraded to the central scheme. So these figures keep changing, my lord. This is a dynamic figure. So every day that is changing. So, my lord, can I propose, my lord, one thing?
Yes.
My lord, since this is this doesn't seem to be subsiding, my lord. I was talking with the officials, my lord. Can we make a PowerPoint presentation, my lord, of what the government is actually doing? Because a widespread
We'll have to
campaigning
make a
is being made.
presentation to him more than to us.
No, at
He
least
has
your
to be
lordship will
satisfied.
appreciate, because the officials, they have said, my lord, they are doing widespread campaigning and awareness programs just to initiate people to come into the centers and register themselves. No one is insisting on any document, my lord. Anybody who can enter the center, register themselves, and after a short inquiry, my lord, they will be included. Every section, my lord, every vulnerable section of the society has been included, my lord.
My lords, recently, my lords, as late as December 2021, my lords, there was a survey conducted, my lords, in Kalahandi district in 7 villages. That survey report is something that I've also brought before your lordships in my additional affidavit.
Where is that?
Well, it's the additional
Flat 50.
affidavit that I filed on 6th of January 2022, my lords.
Yeah, correct.
Please, my lords. Annexure 1, my lords, in that, which is a report, a field study by, there's this NGO called Right to Food Campaign, my lords. There was a survey conducted on specifically these exclusion, because the endeavor is to find reasons why people are being excluded. That is, my lords, the endeavor with which, my lords, the petitioner also has approached. If my lord sees page 14 of that affidavit.
This is an affidavit of 6 January 22, right?
Yes, my lords.
But the affidavit is only 7 paragraphs.
No, my lords. My lords, there's
Page
an
14.
annexure. my lords.
Ah.
The annexure
Do you have a
starts.
copy of this affidavit he's talking about?
You have yes, yes, I
6 January 22.
6 January.
Which is the affidavit you were speaking of, where you said Aadhaar is not compulsory?
Last occasion, that was what is my.
No. Where is your affidavit? Have you filed an affidavit?
Yes. We have filed that we.
That affidavit that.
21/3/22.
1 minute. Let's just see that.
I've also served a copy on him.
Yes. I've received the copy.
Have you served your affidavit on her? That's
that also has been served. It's the 6th January.
6 January.
6 January affidavit, my lord. I'll reply to his affidavit.
No. Do you have it or not as a question?
I'll just.
This 25/3 is not there. It says 21/3.
6 January, no?
21st March, Mr. Patnaik. 21st March, he says is not there.
With the lordships?
Yes.
I'll do it.
You have a copy?
Yes, my lords. I have a copy.
Show us that. Show us one copy.
Yes.
Say an affidavit has been filed. An affidavit dated 21st March 2022 has been filed by the Principal Secretary to the Government Food Supplies and Consumer Welfare Department in response to the order dated 15th February 2022. It is stated that
at para 2,
the database of beneficiaries under the State Food Security Scheme is dynamically updated through 378 Ration Card Management System (RCMS) centers, which are functional throughout the year in 314 blocks and 64 urban local body offices throughout the state. So it is claimed that any person seeking food security can apply for a new ration card, and existing beneficiaries can update their cards through these 378 RCMS centers. It is specifically denied. It specifically stated that, open quotation, no eligible beneficiary enrolled in the state food security scheme is denied ration entitlements due to want of linkage of Aadhaar. Unquote. It is pointed out that beneficiaries in the categories of leprosy affected, old age persons, terminally ill persons, differently able persons are treated as special cases even without Aadhaar. Paragraph. Ms. Patnaik on instruction states that the government officials would like to make a presentation to the court of the steps being taken by the state government proactively to increase the coverage of beneficiaries under either the central scheme or the state-sponsored scheme. Paragraph. Learned counsel for the petitioner refers to an affidavit filed on 6 January 2022 about which inter alia includes a report of a field study conducted in Kalahandi district in 7 villages.
Yes, ma'am. 7 villages
of the Kalahandi district by the Right to Food Campaign Orissa chapter and the Lok Shakti Abhigyan. A copy of the said affidavit has been handed over.
Yes, I have
to Mr. Patnaik, who states that she will have the officials examine it and give their response. Month of May. Up to 5th, is it? 17th May at 2 p.m. You can ask them to make the presentation.
Little time will take for the presentation, but I'll.
Yeah, 2 p.m.
Yes.
And they can, if the officials can make the presentation online as well. They just have to share their PowerPoint.
Yes.
They can sit in their offices and make it.
Oh, bless.
All right. You can give the link of the hearing to Mr. Savantra. He can watch it from wherever he is.
Weekly list item 26.
Lord, copy of the supplementary counter affidavit has not been served on me, Lord.
I'll solve it.
All
I'll
right.
solve it.
All right. Copy of the supplementary counter affidavit. Be served on counsel for the petitioner within 3 days. What's the position, sir, now?
Lord, I have your lordship has the copy of the affidavit, Lord, supplementary affidavit. Now we have stated that the tender which was floated in the year 2018, that bridge is under construction right now. So far as the subsequent tender which was floated for another bridge, it got cancelled subsequently because it was a single tender. And currently the district administrator is saying that there is no need to construct a new bridge.
Yeah, so only one bridge.
Because there is a distance of only 2 kilometers between both the bridges, proposed bridges.
Lord, let them serve a copy. Let me go through the copy and I'll file a rejoinder if necessary.
All right. Counsel, the petitioner seeks leave to examine the said affidavit and file a response, if any, there. Just on 21st July.
Will common?
21st July.
Lord, your lordship fixed a date?
21st July, sir.
Oh, bless.
Weekly list item 27. Item number 27.
Mr. Pari, what is the position?
May I please, madam? On behalf of, I am on ASJ, I am. In the meanwhile, PO has already joined, madam. Taken over charge.
You joined Cuttack?
Yes, yes.
All right. Court is informed that the presiding officer of the DRT is joined. For the moment, therefore, no further directions are called for the present petition. It is disposed of.
The name of land, the name of land SGI along with D. Gochayat CGC may be reflected in.
All right. All right.
Weekly list item 28.
28, we have not yet got any counter. This is
counter is getting ready, but I have received instructions. Your lordships kindly turn to page 54. These were all appointment made under the 13th Finance Commission. Kindly see page 54, man. My lords have page 54.
Yes.
This was the advertisement pursuant to which they were appointed. And if your lordship sees first paragraph itself, my lords. Application,
contractual basis.
Lordship pleases. And kindly turn over the page. It was not only contractual. Serial number 8 made it very specific that it shall not be beyond 31st of March.
After which it has been continued every time.
Lordship pleases. So therefore, my lord,
so, but I think all continuations, as far as I remember, are only till the regular selection happens.
And
all continuations are only till the regular selection happens.
Lordship pleases. So therefore, my lords, in the rules, first of all, my lord, they were contractual. It was for a fixed tenure. Thereafter, it has been extended because the lordships have been asking the state government to extend it. Now, my lord, even page 59, if your lordship sees their appointment letter, kindly see serial number 1, page 59.
Service is purely temporary.
Purely temporary. Contractual assignment for 3 years. Kindly see, my lord, up to so and so, which shall not entail you to claim any regular appointment. And now kindly see they're challenging a rule. If your lordship sees the rule, my lords, they are challenging rule 6. My lord, let us assume your lordship squash rule 6. Page 137. As a one-time measure, there is a provision for absorption.
In fact, it's made specifically for managers, court
Lordship
managers.
pleases. And that also, I find nothing wrong. It is subject to a suitable test to be conducted by a committee constituted by the Honorable Chief Justice. What more? What
So,
can be
Mr.
more fair
Monty,
than this?
what is wrong in having a suitability test?
Lord, they were Well, my first contention is they were appointed after following test.
No, that was contractual.
All contractual appointment within the state government who has completed a period of 6 years has been regularized.
No, but if it has to be subject to certain basic fulfillment of some condition, what is wrong with that?
Yes, all contractual employment. Your 13th Finance Commission.
So, Mr. Monty, we'll do one thing. Let the regular appointment happen.
Lordship, please.
Yes, let the regular appointment happen. The writ petition is pending. We'll say it will be subject to the outcome of the
Lordship, please.
Your Lordship has not
when they're appointed.
Your Lordship has not granted any stay, my Lord. I don't think your Lordship has granted any interim order. But
no, they're not.
Your Lordship may clarify that. Your Lordship may clarify that.
But your Lordship,
it is their own government.
Matter be heard either way, my Lord.
That's right. No, you're right on that. Matters to be heard. That is no question.
My Lord, when their own government, that they gave one computer examination and one viva, and if your Lordship sees now OPSC, what is the rigor of their appointment? Kindly see page 138. My Lord, there is a whole selection process. I can understand that was an appointment for 3 years, understandable. Kindly see page 138.
They have continued beyond 2015, Mr. Parijat.
No, Mr. Monty, we are talking of two distinct provisions. One is absorption of existing court managers, Rule 6.
Yes.
Direct recruitment, Rule 7.
Yes.
Right? Direct recruitment need not stop. Absorption under the existing rules need not stop. It will be subject to the outcome of the
Lordship, please. Your Lordship may clarify that.
All right. Neither will.
Another point is that if the state government, it seems Advocate General is very anxious. If all other state government has regularized the court managers,
no, there is a
why should
for this?
Why
let
should
the rule, Mr. Monty, let the rule operate. It will be subject to the outcome of the petition. That's all we are saying.
They are court officers. I don't know why they are shy of undergoing an eligibility test at the hands of the Honorable Chief Justice.
Mr. Parija, you have never done any service in your life.
I am very poor at that. I have no struggle. I have not done
any. You will not understand the agony of continuing for 10 years and then apprehension of losing a job.
Mr. Monty, all the more when you gain so much experience, all these suitability tests will be a walkover, cakewalk.
Suitability. If the suitability test, regular selection test has been given a go by in case of thousands of employees.
No. Also the nature of the job, Mr. Monty, it's also the nature of the job. Court manager is a rather responsible.
Qualification remains the same. They possess the eligibility.
Anyway, we'll examine all that. We'll say final opportunity is granted to the opposite parties to file their replies within 8 weeks, rejoined up to the next date. It is clarified that the processes for absorption of existing court managers in terms of Rule 6 and the selection process for direct recruitment under Rule
7
and 8 will go on. As far as the absorption of existing court managers is concerned, it will be subject to the outcome of the
last time, Lord, if I may remind you of that, last hour I do not want to drag your Lordship. Last time your Lordship reminded that if any cause of action of the apprehension of retrenchment, your Lordship told that if somebody is not selected, then you can approach.
You can still, the same thing I'm repeating even today. So it will always be open to people to approach.
In the direct recruitment. They can participate.
No, they will. They should.
And they will participate without
prejudice to their rights and contentions.
Right.
All right.
That may be observed, my Lord. It is open.
It will be open to the petitioners to participate in the process without prejudice to the rights and contentions.
That will be very fair, madam.
Yes, absolutely. Right.
Well, another aspect, your Lordship, since Advocate General is there, my Lord, about those increments promised, my Lord, to 55,000.
Their service would have gone after 3 years.
Another matter of 10,000 rupees, I don't think the state is spending so much of money, my Lord. For although they are getting less than your additional standing officers.
All right. Yes.
Deeply obliged.
All right.
Weekly list item 29.
It may please your lordship, my lord, I am in virtual mode, my
Yes.
Lordship, item 29, I am for the private opposite party.
My lord,
25th, I entered appearance. I am seeking 2 weeks time to file counter.
my lord, your lordship, I see your lordship has directed
this is the
the
case
state
where your
council to take instruction whether opposite party number 5 has the eligibility to be the president of the UN governing body of UN College, Soro, my lord.
Correct.
It is he has no
Yes.
eligibility as per the rule, my lord. Therefore, your lordship has directed the state council to take instruction, my
Right.
lord. in the matter.
Lord, the collector
Your
has
lordship
addressed a
can
letter to
come
me
to
and
the
saying
rule,
that
my
he is an educationalist because he was serving in Lord Ramakrishna Shiksha Niketan Chhatarpur.
This has to be
He is an advocate, my lord.
or educationist.
Yes.
He is an advocate and FPP.
No, he has got a license. What
Not license, he is FPP. I have given the notification under Annex 3. He is serving as additional public prosecutor in JMFC Court, Soro.
Yes, my lord. I am just clarifying, my lord.
He is not serving as a teacher, my lord.
Because when the biodata was sent at the petitioner's application was in the right side, he has written that he is an educationalist. And supporting documents are also given.
What is the supporting
my lord? He was in Ramakrishna Shiksha Niketan Chhatarpur, Soro, Baleshwar, and
No, he was in meaning what? He studied there.
No. That besides academic certificates, one certificate from the headmaster, Ramakrishna Shiksha Niketan Chhatarpur, Baleshwar, has been produced by the principal, wherein it is stated that Sukanta Mishra is taking classes sincerely since 2nd of January 2018. It is stated
taking classes.
And
How does that make
he is
him
also
educationist?
making curriculum, teaching methods for different sets of students.
Please. You
He
see,
is additional public prosecutor since 2017, my lord.
yeah, the instructions on Mr. S. N. Das, you see on the previous date, the following order was passed, reproduce the order. Today, Mr. S. N. Das on instructions, learned ASC on instructions states that along with the application filed by the petitioner in support of the claim that he is a single quotes educationist, unquote, he had produced a certificate from the principal of the Ramakrishna Shiksha Niketana, Chhatrapur, Soro, Baleshwar, stating that the petitioner, open quotation, is taking classes sincerely since 2/1/2018. Full stop. It is claimed that the petitioner is also, open quotation, creating curriculum, teaching methods for different sets of students of that institution. Full stop, unquote. By no means will the association in the above capacity with one institution for a period of even less than 3 years, less than 4 years, qualified such a person, prima facie qualify such a person to be an single quotes educationist, unquote.
Eminent educationist.
Sorry, eminent educationist.
Yes.
Full stop. Correct. Consequently, the appointment of opposite party number 5 as president of the Upendranath Degree College, Soro, is hereby stayed. In the main matter, you say counsel for opposite party 5 seeks some more time to file a reply. The reply be filed within 4 weeks, rejoinder before the next date. State shall also file its reply within the same time. List on 19th July, sir.
Yes, ma'am.
All right.
Weekly list item 30.
May I please? Here in this case, the question the revenue is trying to place whether phase 4 of the appeal.
No, condonation of delay.
7 days.
7 days delays condoned. All right. What's the question now?
Whether on the fact and circumstance case, the London ITAT is justified in holding that expense in respect of which tax was deducted during the month of January and February 2007 was allowable to the assessee understanding.
What will be the tax effect for all this, sir?
Sorry?
What is the tax effect?
Tax is more than Lord crores of rupees.
All right.
It is about here the fact remains in the month of the section 2 amendments are there. So far as 142 AI. And in these issues considered by the tribunal held that the similar issue has already been decided in this But he has not referred which decision he is referring. He has not, is silent about this. He has not stated which decision. Number two, any deduction of tax is complied with the 144C. Once you have paid the amount, you have to deduct the tax. And it should be paid in the last month, I mean March, not in the date of date of filing of the return, as is amended the provision 142AI. Therefore, my Lord, the Lord Tribunal
Okay, you just say notice in the main appeal.
Yes.
Returnable on 1st August. Tracking report will be placed.
Weekly list item 31.
Second one is not this issue was not this issue has not Supreme Court has taken both these issues not in two contradict judgment on the issue of not page 5
222E.
One is not the National Travel Agent Service is in favor of the revenue and it's referred to the full bench. But fact remain, my lord, while it was in the full bench, the petitioner withdrew the case because of the scheme. Another is against, my lord, that is Commission on Income Tax for Ankit Private Limited arising after Delhi High Court judgment. Two judgment I am citing, and the question has not yet been reached as finality.
No, but for this SSC is already withdrawn.
Withdrawn, but the question is framed by the Supreme Court has not yet been reached finality because two judgments are there. One is Ankita and another is National Travel Service. I'm patient with
No, but if this titanium mineral has opted for that Vivad se Vishwas.
Yes.
Then why entertain this?
But the Supreme Court in National Travel case told that the judgment which is Akita is not satisfied with that judgment.
Here it becomes academic, isn't it? If this petitioner has...
The fact remains, whether the person who has given loan to the company is a registered shareholder or not, that is the issue. And the section says that any payment, there is no scope of any registered shareholder or unregistered shareholder.
No, but I'm not able to understand. If this SSC is opting for settlement and suppose you accept his offer.
No, not these SSC, Lord. The SSC before the Supreme Court.
I see.
I'm just placing these two judgments.
I don't know all this after 11 years and 12 years we're issuing notices to these people. I don't know what the fairness of that is. They would have arranged their whole affairs thinking no department is going to challenge any of the orders. All right, you just say notice returnable same day. All right. Doesn't seem fair actually, but not bringing up these appeals for hearing for so many years.
Weekly list item 32. Item 32.
The question frame at page number 6. The third question is very important. Whether in the fact and circumstances of the case, the London ITAT was justified in totally ignore the implication of provision of section 36(1)(7) in simply confirming the finding of the first appellant authority regarding admissibility of the entire amount of 5.28 crores claim as bad debt written off. Tribunal order.
Which paragraph of tribunal order, sir?
Yeah. 26.
SSC's own case, sir. Earlier order is there. They're just following the earlier order for the SSC's own case.
Yes.
You say the present petition, the present appeal by the revenue is directed against the impugned order date. January 2011 passed by the Income Tax Appellate Tribunal, Cuttack, in ITA number 75 of CTK of 2010 for the assessment year 2006-7. One of the questions sought to be urged, the question sought to be urged is regarding the ITAT concurring with the order of the CITA who ordered deletion of the additions made by the assessing officer of the amount claimed as bad debts written off. Full stop. it is seen from the impugned order that the ITAT was following its own earlier order, own order for an earlier AY in the assessee's own case. Paragraph in that view of the matter, no substantial question of law arises. The appeal is dismissed.
Quick list item 33.
Yes, my lord. Question framed at page number 5, my lord.
Yes.
Whether in the fact and circumstance the demand is more than 1 crore, whether in the fact and circumstance case the landed active was justified in holding that the determination of undisclosed income in the hands of the assessee on the basis of the seized document was not warranted, expect material evidence to the contrary. Second question is that whether in the fact and circumstance case the landed ITT was justified in deleting the addition of 68,72,577 being confirmed and rupees 41,45,040 announced by the landed CIT appeal on the basis of the entries made in the seized document. But the order has been passed at.
So in which appeal are you filing this appeal? In which corresponding appeal? For everything you're filing one common appeal?
Yes.
I don't know how this is permissible. One appeal for several appeals of the department.
I file only one appeal.
Sir, but you're including all appeals of which is there before the ITAT.
There are 8 appeals are there.
For which you're filing only one appeal here.
Yes.
What? Yes. How is that possible?
Only 7. Only 7.
What's
appeal
only
number 7 is.
You should be filing corresponding 7 appeals here. How can you file one appeal, sir? For 7 corresponding appeals in the ITAT.
There are 8 appeals before the tribunal. I filed only for the 7. Shiva Prasad Das, Cuttack, ACIT Circle, 1.
So only in one?
Only one. And that has been framed at page number 55. The learned DR supported the order of the learned CIT appeal for confirming the addition and the announcement. She admitted that the
concurrent findings, sir. Shiva Prasad Das. What page is that? 55. You say the present appeal by the revenue is directed against the order dated 23rd June 2011 passed by the ITF in ITA number ITSSA number 3 and 4 public CPK public 2002 in the cross appeals in the case of Shiva Prasad Das. Paragraph, the question sought to be urged concerns the ITAT upholding the order of the CITA that the determination of undisclosed income in the hands of the assessee was not warranted. The court finds on examining the impugned order that there are concurrent findings of fact by the CITA and the ITAT on this aspect, and therefore no substantial question of law arises. The appeal is accordingly dismissed.
Weekly list item 34.
In court to 39 minutes, I am appearing for the opposite parties. The mailers, opposite parties, mailers, the crux of the matter, the initiation of the assessment proceeding under section 153A, and your lordship have settled it in Kabul Chawla, Mita Gutgutia, and also in these cases also reported in ITR mailers, Jami, Nirmala, that unless there are incriminating materials, then the proceeding cannot be initiated under section 153A. But what has happened, my lordship, may kindly turn to first case, that is 910. There, my lords, page 40, lordship will kindly see the statement which has been recorded under section 131, the all the appeal orders as well as the tribunal orders are common. They have page 40, page 41, my lords. Lordship will kindly see tabular form, the assessment year and the increment material the appellate authority has held. Statement of Debasis party. This is alleged to be the incrementing material. Then B, statement of Vijay Kumar Ponda. This is also alleged to be the
Which page are you reading? Sorry.
Mellors, so far as
Yes. Page 41. Correct.
Yes, page 41. Mellors, like this, and he after
and identical,
and the tribunal, Mellors, the same questions were raised. Lordship will kindly see page 13 of the tribunal order. Page 13, Mellors. The tribunal has passed a common order, and there the tribunal has said, I'll place 13, Mellors, that is 9-10. That the first ground is that there is no incriminating material. The first ground. Lordship, may I place it?
Yes.
That on the facts and circumstances of the case, learned CIT appeal has erred in law. The assessee order upholding the assessment order passed by the CIT, Bhubaneswar under section 153A, in spite of the facts that no incriminating documents whatsoever has been found and seized by the search team. And thereafter, my lords, it appears the learned tribunal has drifted away from the main question. That is whether the foundation of the jurisdiction is there or not to initiate the assessment proceeding under section 153A.
But anyway, it is held in your favor.
My lords,
anyway, the tribunal is in your favor.
A tribunal is my favor, but
I filed appeal, my lords.
Yes.
The question has been framed at page 11.
Yes.
Whether in the fact and circumstances of the case, whether the honorable ITT is correct in observing that the assessment order under section 144, read with section 153 of the IT Act, dated 3/12, received by the SCC on 7/1/2017, could be set as border limitation when there was no indication to show that the assessing officer did not pass the order on 30/12/16. Whether in the facts and circumstances of the case in law, the learned IT is correct in holding that when there are two divergent views of different high court on favoring the SSC should be followed, totally ignoring the fact that the decision of the high court favoring the revenue was confirmed by the apex court in as much the SLP filed in the Segard court. But there are two decisions in favor of the petitioner. I am submitting the Supreme Court Order, Commission of Income Tax, Chennai, Mohammed Murshid Sahamuddin, and this High Court order that instead of that 21 months, 24 months. (153)(b)(2) notice. Instead of 21 months, it will be 24 months.
But that was in the context of 263(2), sir, not 153(a). It's a different question altogether. This judgment is about 263.
At page 9.
No, but the provision they're interpreting is section 263.
263 same, provision is the same.
No, here we are not concerned with 263.
But this High Court judgment is there.
Kindly see page 23 of the tribunal order.
Page 3, paragraph 8.
23. Just a minute. The learned DR could not explain when the orders were prepared on 30th of December 2016, why it could not be dispatched on or before 31st/12/2016. That's may kindly see page 23 of the first that 150 of 2018, the learned tribunals of query at para 9, the learned there would not explain when the orders were prepared on 30th of December 2016, why it could not be dispersed.
The Shiva Cement Limited at page 3, paragraph 8. At the time of resumption of hearing today, the London Council for the Revenue, upon instruction from the department, very fairly considered that the period of limitation for the concluding the assessment proceeding under section 153A of the IT Act has been provided under section 153B. 153B section, it is 24 months, which was in operation at the time of search on 24/9/2014. And here the search has been made on 28/5/14. And not the period of limitation as substituted by the amendment with effect from 16/2016. It is not the dispute that as per the period of limitation, operational with effect from 16/2003 before its amendment with effect from 16/2016 provided the period of limitation for completion of the block assessment year within 2 years. So this notice has been served within the time period.
No. If it's within 2 years, it had to be before 30/12/2016, correct?
Yes.
It is 21 months, 7 days.
21 months, 21 within 2 years.
Not 7 days.
21 months, 7 days, and he has passed order within 24 months. 153(2)B, 153B.
153B.
Mr. Rai, do you want to examine this?
Yes, Lordship, also,
Time limit.
may I pray your Lordship also put another question while examining. I will definitely examine this. Whether in the absence of any increment materials or the statement as has been recorded under section 131 can be said to be an increment. That will oblige my Lordship.
But then you'll have to file a cross thing for that.
My Lordship, I will file. Lordship, may file.
Or at the request of Mr. Rai, who appears on advance notice list on 13 July. All these matters, 34 to 39.
Weekly item 40.
Same, my lord, for 5 years.
Yeah.
6 years.
34 to 39, my lords. And may I pray, my lords, may direct Mr. Chimaka to provide me all the copies, my lords.
Copies of all the papers.
At least he is not giving a cup of tea. Let him provide the copies.
Coffee, not copy.
No. Definitely provide a cup of tea to Mr. Rai.
Obliged. Much obliged.
Okay.
Weekly list item number 40.
May I please, my lords?
Yes.
Well, the question raised is at page 13, my lords. Only one question is involved, my lords.
All right.
Page 13 of the brief, paper book, my lords.
Okay.
Whether in the facts and circumstances of the case, the raw material purchased by the petitioner for the purpose of adjustment of eligible exemption amount as against the certified exemption limit in terms of entry 43A, you will also kindly read as 42A because it's a typing mistake. 42A of the final department notification number so dated 23/9/92 is to be calculated at the rate of 16% as held by the tribunal as against the rate of 4% claimed in assessment. The judgment of the tribunal, I will take your lordship's attention directly to findings at page 28.
Mr. Sahu, can we do this tomorrow?
My lords, no difficulty.
Oh, all right. Tomorrow. All right.
Yes, I have given judge.
Which matter? I'll keep it for 18th May then. All right. Tell them.
Yes, I have filed some judgments. My lords may kindly take on record. I have given 2 judgments.
All right.
Directly on the issue.
Okay.
Obliged.
All right.